Test, this is a test. Test, this is the seventh circle test.
Good morning. Our first case of the day is Kaiser versus Alcoa USA Corporation. Mr. Remier.
May it please the court. David Raymer for appellants Alcoa USA Corporation and the health plans. Your honors, the whole point of judicial estoppel is to prevent a party from winning one suit by arguing A and a second suit by arguing not A. Yet in the litigation below, the district court estopped Alcoa on the basis of representations it did not make in a suit it could not have won on the basis of those representations. What is more, the district court did this after certifying a class alleging the breach of dozens of distinct collective bargaining agreements without identifying any common terms among those contracts, many of which were not even in the record, and without any regard for the reality that the relief plaintiff sought was fundamentally incompatible with the Rule 23b2 class. All of that warrants reversal. Alcoa is aware of no case in which a party's been estopped in even remotely similar circumstances, and it simply cannot be the law that a court can certify a collection of contract claims without the underlying contracts.
So with regard to that point, turning to class certification, I believe in your briefs you point out two different types of CBAs, generally speaking.
Correct.
One are those that are silent as to the duration of the retiree health benefits, and the other are those that provide the benefits shall continue for the life of the agreement. In either case, at least it seems like from Cherry and our prior cases, Rosetto, that the objective extrinsic evidence can be used to create some ambiguity with regard to those contracts. And it seems like in both cases, the objective evidence, if you take plaintiff's theory, seems to at least raise a question as to ambiguity with regard to those two types of CBAs. And so why can't the district court on a 23b2 class just focus on that common issue and certify the class as the district court did?
So a couple responses, Your Honor. In the first place, I don't know how the district court is supposed to conduct that analysis with respect to the contracts that are not in the record. We have approximately 600 of the 3,000 class members in this case who are governed by CBAs that are not in the record, even under Cherry and the cases that plaintiffs cite.
But are there, other than the two broad categories of CBAs that you identified, are there any other variations with regard to that particular issue?
Well, quite frankly, Your Honor, we don't know because those contracts aren't in the record. Plaintiffs are alleging a breach of a contract where they don't know what those terms of those contracts say because those contracts haven't been located, they haven't been submitted. And even with respect to the contracts that are in the record, Cherry and that line of cases all require interaction with the terms, with the language of the actual contract. And that analysis is going to be different for each contract at issue because you have to see not only whether there is an ambiguity, but you also have to see how whatever extrinsic evidence plaintiffs put forward interact with the other terms in that contract.
Well, they don't have to establish that the contract in and of itself within the four corners is ambiguous, right? I mean, that's the Peerless case, that even if the contract within the four corners doesn't appear to be ambiguous, one could use objective extrinsic evidence.
But this court has said in Bidlack that even in that scenario, there has to be some language in the contract that you hang the label ambiguous on. Even in your Peerless example, Your Honor, the word Peerless was in the contract. You had to have the contract to know that there was a ship called Peerless that you were even considering. So again, I don't know how you conduct that analysis if you don't have the contract. And I don't know how you do that across a class if you don't have common terms that are in each of the collective bargaining agreements. And there's been no indication whatsoever of common terms among the entire universe of dozens, potentially hundreds of CBAs that are at issue here, either that directly award plaintiffs vested benefits or on which you could even hang the term ambiguous. So even under this court's precedent on latent ambiguity, you still have to have some common terms. We're aware of no case, all those cases also involve individual contracts, and all of those cases had the CBAs. The court was interacting with the specific language of the contracts at issue there. We're aware of no case, particularly in this context, where if retiree medical benefits vest at all, they vest pursuant to the terms of a specific contract. That's what this court has said repeatedly. So I don't understand how you have a breach of contract claim across dozens of distinct collective bargaining agreements that relies solely on extrinsic evidence without any regard for what those individual contracts say.
What about the district court's finding that, as to the master agreements, that they have substantively identical language?
So even with respect to the master agreements, we're not considering those master agreements don't apply across the board. They only apply to a specific subset of the pre-1993 population. And there's no language that's even been identified in those master agreements that are common across all contracts. The district court pointed to a couple of phrases which plaintiffs notably don't attempt to defend on appeal that were just completely divorced from any context. They basically involve situations in which government legislation impacted the level of benefits being provided, and in that case, the parties would get together and negotiate adjustments.
But we would review that finding under clear error, right?
I believe class certification decisions are reviewed under an abuse of discretion standard.
No, but the factual finding that the master agreements had substantively identical language, that to me seems like a factual finding that we would review under clear error.
I think it sounds much more like the sort of typical contract interpretations your honors normally would review under, a de novo standard. Even in the case of an abuse of discretion standard, it's very often that there's underlying legal prerequisites that this court is going to review, at a plenary level before deciding whether, when it pieces all together, the court abused or did not abuse its discretion in certifying the class. And again, even if you take those master agreements, there's, that is not common across the entire class. And you have distinctions, again, to the language even the district court pointed to. Some of the CBAs in the record don't even contain the language the court pointed to about government reductions in benefits or adjustments to benefits. So, our bottom line position on this, Your Honor, is that whatever standard of review you're applying, if you're certifying a class action for a breach of contract, you at least have to have the contracts before you. You have to identify some common terms so you can decide whether or not this is something you can resolve all in one stroke. And that's even without getting to the problems with the B2 class here, Your Honor, where the district court essentially certified what is for all intents and purposes, a claim for individualized damages. You have plaintiffs who are you have class members who are now going to have to submit individualized medical records that Alcoa or its representative is going to have to review. They're going to have to compare them to the terms of the prior plan. They're going to have to compare them to the terms of whatever medical coverage.
But Alcoa would have to do that regardless for any future benefits, right? So assuming, let's take the prior claims out of it, right? So if we affirm the district court's decision, Alcoa would then have to reinstate the procedures that it was using
Correct.
To administer these claims. And so the only difference between administering the prior claims and the past claims, it seems to me, is just whether or not that there were kind of double recovery issues in the prior claims to see if the putative class members received any benefits from other sources. But other than that, it seems to me that the procedures would be the same, right? I mean, the review would be the same, because that's what plaintiffs are asking for.
But that's also not insignificant, Your Honor, because you're going to have to look at whatever prior coverage was available.
It's not insignificant, but is it legally incidental? I mean, I guess that's the question.
No, Your Honor, because it adds another factor. It is anything but purely mechanical. I mean, when this, again, as you well know, B2 class actions, individualized monetary relief is only appropriate if it's incidental, and this court has said that means it involves no more than a mechanical computation. And we'd submit, Your Honor, that if you're having to take two plans, see whether a claim was covered under one, see whether it was covered under the other, then factor in co-payments, insurance, deductibles, all of that. Frankly, with respect to prior claims, I'm not even sure how you factor in what they paid with respect to deductibles, because that's done as lump sum over the overarching scheme of their benefits as opposed to one individual claim. And then also in this case, you have to compute interest as well. So there's additional computations that come into play in this case that just aren't here when you're talking about prospective looking
What
forward.
would your limiting principle be for that? Because if there was coverage, there was an obligation to do that in the first place. And I think part of what Judge Lee is getting at, we're just shifting the time in which you had to do that. It seems like your rule would essentially say there's no class actions for anything related to coverage disputes.
No, Your Honor, because again, there's another factor that comes into play here. There's whatever coverage they had at the time, and that puts this kind of, again, in this court's bucket that we discussed in Jamie S., where not only do you have these individualized determinations, but B2 class actions are also only appropriate when the relief award is final. And what the court is doing in this case is it's not offering final relief to the parties as a whole. It's setting up basically an individualized claims processing process whereby Alcoa is going to set up a process out of court to basically, do what plaintiffs literally said they were doing to avoid the court having to take the time and effort to do. Plaintiffs themselves recognized the burden involved in computing these claims. They initially brought this request as a damages request, and then, when it came time for judgment, they literally said, well, actually, no, just do what we said as damages, do that as an injunction so that we can avoid the time and effort of processing all those individualized claims. If plaintiffs themselves think this is burdensome, I think that's strong indication that this is more than the purely mechanical process this court has contemplated in other contexts.
Do you mind if we transition to judicial estoppel?
By all
In the
means,
limited
Your Honor.
time that we have, how did Alcoa in the Curtis litigation distinguish between the pre and post 1993 retirees?
Well, in the Curtis litigation, Your Honor, the only retirees at stake there were the post-1993 retirees. The pre-1993 retirees weren't even before the court, and Alcoa made no representations whatsoever regarding the pre-1993 retirees, and to the extent it did, it wouldn't have mattered because there's literally
There's,
nothing.
in the Alcoa opposition, there's a reference, docket 132-4, plaintiffs here seek to receive benefits as if they had retired before June 1st, 1993. So I think it's a little bit of an extension of that there was a reference to pre-1993.
Sure. What Alcoa was doing with that representation was essentially trying to illustrate the absurdity of the Curtis plaintiff's position. The parties
Illustrate what? I'm sorry.
the absurdity of the Curtis plaintiff's position. The parties had spent many, many hours negotiating a cap on post-1993 medical benefits. The Curtis plaintiffs walked into court and basically said that cap literally doesn't matter. We should be able to receive benefits as if that cap doesn't exist. Alcoa was saying that's ridiculous. Again, the whole litigation was about the cap. To read into that anything regarding Alcoa's position on vesting just doesn't make any sense whatsoever, particularly when we consider that these are two stray comments and Alcoa's consistent position throughout that litigation, including in its post-trial brief at JA 316, is that retiree medical benefits do not vest. It would be quite odd for Alcoa to reverse its lead argument in its post-trial brief on the basis of those passing remarks.
We've used that word quite a bit, vest. And there's a lot of paper on how that word is used. Can you just give us a snippet of how you're using vest?
So in this
Vested.
context, we're talking about it in terms of whether or not plaintiffs are entitled to lifetime retiree medical benefits that can't be altered.
I'll give you more time on rebuttal. If I could turn to class certification again for a second. I guess stepping back, it seems to me that the parties' positions are these, and if I'm reading it wrong, please correct me. The plaintiffs are saying, the whatever the contracts say, that the 1993 negotiations between Alcoa and the unions demonstrate that neither Alcoa nor the unions thought that the retiree benefits terminated at the time of the expiration of the agreements. It seems like Alcoa's position is, well, there are actually two groups of contracts. One has no language with regard to the termination, and the other one says it's terminated with the agreement. And under either one, the parties understood that the retiree benefits ended, eligibility for retiree benefits ended when the agreement terminated. Okay, so then the plaintiffs come back and say, whoa, no, because whatever the agreements might say, look at what happened in 1993 and all those post-negotiations, okay? And I guess I have two questions to that. One is whether or not that my kind of characterization of the parties' positions and where we are is correct. And second is if Alcoa thought that and believed that the benefits ended for the pre-1993 retirees at the termination of the agreements, why did it engage in these negotiation process to try to cap those benefits anyway?
Sure. Can I answer, if I'll answer your second question first. You have to remember that at the time Alcoa was negotiating those agreements, Yardman was on the books in the Sixth Circuit. So Alcoa definitely took the position that retiree medical benefits don't vest. That's all throughout the Curtis litigation. But at the same time, it realized that the instant it did anything to those pre-1993 retiree medical benefits, it was going to get sued in the Sixth Circuit. And in that case, the Yardman presumption was going to apply, and the thumb was going to be on the scales. So regardless of what Alcoa thought the correct interpretation of the law was, it realized that there was a real litigation risk to doing anything with respect to the pre-1993 retirees. So it decided to mitigate that litigation risk by engaging in these negotiations for capped benefits. So you trade an uncertain liability for a certain. That's why the negotiations made economic sense. As to your initial question, I think it's a bit broader than just those two claims. I think Alcoa's position is fundamentally that whatever was said in those 1993 cap negotiations, you just can't use that extrinsic evidence without being able to, certainly not without respect to contracts that aren't in the record, and even with respect to those contracts that are in the record, you have to have some common language in there on which to hang the label ambiguous.
What if the plaintiffs come to you and say, hey, we're willing to stipulate that all these other agreements, there are two categories, as you say, as you meaning Alcoa, they either fall in two buckets. They either have no language or they have language saying they terminate at the end of the agreement. We'll stipulate to that. And so then we will only focus on the 1993 negotiations and going forward. Would that address the issue?
I don't think so, Your Honor, because even in that case, you still have to determine how that extrinsic evidence interacts with those buckets of cases, and that's going to vary based on what the remainder of the contractual terms in those agreements exist. And, there is no such stipulation in the record, and again, it seems passing strange to do that with respect to contracts governing 600 class members that aren't in the record.
So is it your concern that Judge Young used this common question being the negotiations? The common question should have been, what I'm hearing this morning, more focused on the underlying collective bargaining agreements.
Correct, Your Honor. Again, this is fundamentally a breach of contract claim. I don't understand how you litigate a breach of contract claim on a class level without some common terminology among the contracts, or even without the contracts themselves.
Mr. Raymer, I'll give you 2 minutes on rebuttal.
Thank you very much.
Thank you. We'll now hear from Mr. Hurst.
Good morning. My name is Joel Hurd. I'm here on behalf of plaintiffs in the certified class below. I guess I will address the class certification issue and the issue regarding missing contracts, as Alcoa has described them first. The first thing I want to say is that the CBAs are in the record for the vast majority of class members. And there's a chart at the joint appendix. I have 50 written, but that's not right. It's toward the end. I think it's 350. that shows, the main contracts and who is covered. It is true that there are some that neither party was able to locate. In fact, maybe 90% of the contracts produced in the case were produced by the unions, but these go back 50 years to 1968 in some cases. And you had a lot of consolidation on both sides, both on the employer side and on the union side, so some just got lost. But what's universally is true is that Alcoa treated all of the pre-1993 retirees that didn't have a cap on their benefits uniformly. They were in the same plan. They administered the benefits in the same manner. When they came to analyzing whether to move to the health reimbursement arrangement, they treated them as one group. They called it the uncapped group. They made the same change at the same time. But with respect to the contracts,
The distinction that was made during the negotiations was those that had retirement benefits before 1993 and those that had were going to be subject to the cap.
that's correct, Your Honor, and that's the whole dichotomy. There's been this fundamental relationship for decades. The pre-93 retirees had lifetime uncapped health benefits, and the post-93 retiree benefits had vested capped health benefits, but got increased pensions, they got increased 401ks, and they got other protections in the 93 round of negotiations, such as making it a mandatory subject of bargaining moving forward. And actually, the post-93 retirees clearly got benefits to survive the expiration of the contract because the cap, which was negotiated in 1993 for a 3-year contract, couldn't be implemented until 1998. So there's these whole facts and circumstances surrounding the 1993 negotiations that just make no economic sense. Respectfully, my colleague, you wouldn't give up all of that. It was a huge issue for the company coming into the negotiations. Their chief negotiator, Russell Porter, said it was the #1 concern going into those 1993 negotiations. Sorry.
Well, what do you do with the conversation, at least on the other side? We heard your colleague mention that, Judge, at the end of the day, this is a breach of contract claim. And so irrespective of if we classify or affirm the classification of, but there's no contract for the court to look at to determine whether or not there was a breach.
Well, a few things I want to say to that, Your Honor. First, we know there were contracts. Both sides agree on that. We know that the company was providing uncapped healthcare benefits pursuant to those contracts. It did it for decades. Under this court's framework for deciding retiree healthcare contract cases, and Judge Lee mentioned this, the Rosetto case and the Cherry v. Auburn Gear case, you can use objective extrinsic evidence to show an ambiguity. There's 4 categories, or 4 bullet points, I guess, in those cases. And the first one's where the contract is completely silent on duration. And the second is where you actually have patently unambiguous language within the 4 corners that's in favor of the company and not the retiree. So in those circumstances, you can still use the objective evidence, here the 1993 negotiations primarily, and you can use those to establish a latent ambiguity. I mean, the same principles would apply absolutely where you don't have the contract, but both parties agree there was a contract and then it provided health benefits. I mean, even if it was completely adverse to the retirees, as is mentioned in Cherry and Rosetto, you're still able to present objective evidence to create a latent ambiguity, and that's our argument here.
Mr. Hurt, a couple of questions. First of all, did you and your colleagues consider excluding the putative class members for which you were not able to identify particular contracts?
Did we consider it? We never presented that argument, Your Honor. We thought the facts that there's no dispute. First of all, at the beginning, we didn't know the universe of contracts. We had to get the information from the company in discovery of who retired when and from where.
And by your estimation, what percentage of the putative class, are there for whom the applicable contracts cannot be found?
Yeah, that's a good question, and my colleague's using the 600 number, but if you look at the declarations in the record, that 600 number is at best described as people for whom Alcoa hasn't been able to link up to a particular contract. So they may be actually part of the master agreement, some of those 600 people, but Alcoa didn't keep the records, because when somebody passed away, for example, a surviving spouse got a new retirement date that was after 1993 that just can't be connected, or they identified a plant in Mexico which has no connection to the
What's the
case.
denominator for that? So what is the total class?
I believe it's around 3,000, Your Honor.
Okay. So let me ask you, so you want the court to, the district court, you asked the district court to consider extrinsic evidence, meaning the 93 negotiations and the interactions thereafter. That would establish that a particular contract is ambiguous under the latent ambiguity theory. I think Mr. Raymer raises an interesting point, which is that that's just one extrinsic evidence point. There may be other, in the negotiation of those particular CBAs, for example, or in the performance of those CBAs, other extrinsic evidence with regard to a particular CBA, they may be relevant to this question. And I think Alcoa's position might be, perhaps it is, that if you want the court to engage in this analysis of looking at extrinsic evidence, don't you have to assess whether or not there's other extrinsic evidence with regard to a particular CBA that you think is ambiguous? And secondly, doesn't that mean that we have to at least start with the CBA to see what the negotiations were surrounding that CBA and see what other extrinsic evidence might be relevant, in addition to the 1993 and later negotiations?
Sure. A couple points in response to that. First is, we had a full discovery. We had cross motions for summary judgment. We had a very developed record with, scores of exhibits. They haven't identified any extrinsic evidence to that effect. They didn't put any in the record. They didn't oppose our summary judgment motion by putting forth, extrinsic evidence from this contract and this year and this facility. It's just not in the record, Your Honor. It certainly wouldn't be there not to consider it.
It's hard for us to assess because the district court didn't either, right? Because the district court relied upon judicial estoppel. And so at least from the record that's before us, it wasn't quite clear to me what the universe was of the extrinsic evidence that the parties were able to uncover. I can see a world where if the plaintiffs, basically admit that all of the governing contracts have language that on its face is not ambiguous, right? Or unambiguously, I can foresee a strategy where the plaintiffs might say, you know what, we will admit what the contracts did or did not say, and that on its face, as interpreted, that one can assume that the retiree benefits end at the end of the contract, but we're going to rely upon the 1993 negotiations, kind of taking those issues completely, off the table. But the plaintiffs didn't do that here, and so Alcoa's theory has some superficial intuitive appeal that's saying, look, if you're going to look at the negotiation history and the extrinsic evidence to interpret a particular CBA, you need to kind of also look at the CBA and figure out what was going on at the time.
I think we absolutely did argue in the alternative that even if the language were absolutely against the retirees, that we would still be able to put forth and win the case on the objective extrinsic evidence regarding the 1993 negotiations.
On the judicial estoppel question, I know that there's a link made that those collective bargaining agreements suggested that the pre-1993 retirees were entitled to lifetime retirement benefits. Where below did the district court make the connection that Alcoa could not unilaterally modify those benefits.
Where did the district court in the record? I can't give you the precise page to the record, but I can tell you the district court recognized a couple statements that Alcoa had made in the Curtis litigation. The first was in opposition to motion for preliminary injunction. Alcoa said plaintiffs seek to receive benefits as if they had retired before June 1, 1993, meaning the plaintiffs in Curtis were seeking lifetime uncapped benefits, and Alcoa is saying,
But I'm saying if I accept that,
yes,
where is the language that says that they can't modify it unilaterally?
where's the language that they
So we don't have
represented
the
that?
collective bargaining
Okay.
agreements.
Well, the company's lead negotiator, Russell Porter, testified at the Curtis trial in 1993, and this will dovetail with a question you asked Mr. Raymer about the meaning of vesting. He testified that the benefits were not vested as the Curtis plaintiffs saw them, meaning vested like pension benefits by statute, they're forever unalterable. But he said at trial, we cannot make changes to it without negotiating with the unions. In our case, he testified, we can't touch the pre-1993 retirees' benefits. That's his. He was the lead negotiator in 1993, and that was his understanding. So I don't know if that answered your question. I was trying to.
Are the plaintiffs claiming that the pre-1993 collective bargaining agreements gave the class vested lifetime uncapped benefits?
They're arguing that they were vested in the sense they survived the expiration of the agreement, and they cannot be unilaterally reduced by Alcoa. They can only make changes through negotiations with the unions.
On the collateral estoppel, the district court had a lot of discretion there, but phrased our Gerard case as having a principle that a party, the judicial estoppel here, I'm quoting from the district court, the principle applies when a party cannot maintain, this is about, a change in law, giving rise to a change in position, and the district court saying the principle applies when the party cannot maintain its prior position due to a substantive change in the law. And I don't read Jared as saying that the party somehow has to be compelled by the change in law to change its position. And that would strike me as a principle that could get in the way of counsel arguing the case under the existing law. Was that error of the district court to take Gerard for that principle?
No, I don't think so, Judge Kohler. And I guess I just take a step back. This is a very discretionary standard. The Supreme Court of New Hampshire remains that it can't be reduced to a general formulation. There are no fixed prerequisites. 3 factors typically inform the analysis, but there can be additional factors as well. Now, in the Gerard case, a defendant made an argument initially, and then there was a change in controlling Indiana case law. So when it came to the later proceeding, it just had no way it could keep that prior position without running afoul of the law. And the court said in those circumstances, I'm going to not exercise my discretion to stop them. And I think what Judge Young was saying is this is a different case. The point of contract interpretation is to ascertain the intent of the parties. And that the Sixth Circuit had one method for doing that in Yardman. It got changed, but that doesn't mean that the parties' intentions changed. It doesn't mean they still couldn't have vested benefits. They argued that they vested benefits, and they won in the Curtis case. They didn't have to do that. So I think he was saying in those circumstances, that's a different scenario than in Gerard. Maybe it's not the categorical rule that you read the court to say. Maybe that's not appropriate. I see my time is up.
My question with regard to the judicial estoppel issue is that it seems to me that whatever position Alcoa may have taken with regard to the vesting status of the pre-1993 retirees, that fact and that position was immaterial to the claims raised by the plaintiffs in Curtis. Because in Curtis, you were dealing with post-1993 retirees. Why isn't that dispositive of the judicial estoppel issue? Because one of the requirements that the court has to rely upon the representation in reaching its decision. And here, it's hard to see the court relying upon any position with regard to the pre-1993 retirees to reach the decision, because the claims before it had nothing to do with that.
Well, I think you have to understand that, collective bargaining agreements, you don't start fresh each contract each time. You work from the prior contract and you negotiate changes. So one of the things you do under the Rosetto Cherry thing is you look at related contracts at the same facility or even the same employer and industry practice, because they all flow together. There's very little change in language contract to contract, because people don't want to, if they agree on something, they just don't revisit it. They bring it, carry forward. So that's why the contracts are very similar year to year. But the whole fact of the 1993 negotiations, and the fact you had Alcoa's lead negotiator testified they were willing to weather a strike to get the cap. It was their number one priority to reduce retiree health care benefits. They made it only able to implicate the cap after the expiration of the agreement. They made it a mandatory subject to bargaining. None of those positions, none of those facts make sense if Alcoa already had the right in the pre-1993 CBAs to terminate the benefits at the end of the contract.
But one would think that if that was material to the court's decision, as Judge Pryor alluded to, then you would see it in the very voluminous findings of fact that the district court in Curtis issued. And so I was looking for that. I was looking for some reference that would at least give the inference that that was something that the court was relying on to reach its decision, but I couldn't find it in the Curtis court's
I think it was
order.
so prevalent and so assumed that even the Sixth Circuit said it explicitly, that the 1988 contracts contained vested lifetime benefits.
Before you sit down, if I could ask you a bit more about the class certification issue.
Sure.
So, you said you argued in the alternative that assuming the contracts on the Four Corners provides that the retiree benefits would terminate at the termination of CBA, that the 1993 negotiations and R would create latent ambiguity. I guess my question to you is, for the purposes of appeal, are you prepared to concede at this point that to the extent that there weren't any contracts, they can't find specific contracts, that on the Four Corners, that those contracts should be interpreted or can be interpreted to state that the retiree benefits terminate at the end of those CBAs?
I'm not prepared to stipulate to that as a matter of fact, because I don't think it's accurate, and we have record for the district court otherwise. But they're certainly making the legal argument that even if the court were to disagree and find that were the case, we would still be able to present the objective evidence of the latent ambiguity.
Okay. Thank you.
Thank you.
Judge Lee, you're absolutely right. It simply cannot be the case that Alcoa could be stopped on the basis of any representations made regarding the pre-1993 retirees in the Curtis litigation, because the rights of those retirees were simply not at issue there. But even more fundamentally,
I need to stop you there. I understand Judge Lee likes it when people think he's right. But when we say...
How do you know that?
I know you. But the question that we're having is, the back and forth is, in those findings of fact, the plaintiffs asked, in the Curtis litigation, the plaintiffs asked, let's clean this language up. and have the plaintiff say healthcare benefits under Alcoa's plan are vested lifetime benefits in according with paragraph 236 and 237 of the findings of fact. Alcoa comes back and says, depose that modification, and said the plaintiffs were entitled to vested benefits. And the language, I'm going to read it here, it says, even before this court's ruling, Alcoa was committed to providing benefits to members of the plaintiff class at the 2006 cap level. As such, a formal order that those benefits are vested would provide members of the class with nothing more than what Alcoa has agreed to give them.
Sure, and a couple points on that. That all has to be read in context. The commitment to provide them was referring to the 2006 CBA that was in place at the time. Alcoa was referring to only the post-1993 retirees in that context, and there was an express CBA on that point. Again, we are talking about pre-1993 retirees in this litigation. And not only was there no representation regarding the rights of pre-1993 in the Curtis litigation, Alcoa couldn't have won anything on that basis. And that's why, Judge Kohler, no matter how much discretion the district court had, what it did here was beyond the pale. Because if judicial estoppel means anything, it means you actually have to assert inconsistent positions and actually win something on it between two litigations. And that's just not what happened here.
Thank you.
Thank you.
We'll take the case under advisement. Thank you, counsel. The next case is Lee versus Lutzik, case number 242647. All right, Ms. Walsh, whenever you're ready.
Thank you, Judge Lee, and may it please the court. Officers here intentionally destroyed evidence because they knew Mr. Lee could obtain it in discovery. The officers have testified to such, and the state has conceded that it violated Mr. Lee's due process rights under Youngblood and Trombetta. And yet, when the trial court was fashioning a remedy for the violation of Mr. Lee's due process rights, it was concerned about protecting the state from adverse jury inferences over this destruction. A remedy that was meant to protect the officers who violated Mr. Lee's due process rights is no remedy at all. And because of this
Mr. Lee, was he given, didn't he request in the alternative to not allow the state to call those three witnesses?
No, Your Honor. His alternative requested relief was actually different than what the trial court did. He had never asked for suppression, nor did he ask for anything about his ability to present evidence on the officer's destruction of evidence. He had requested only in the alternative that the three witnesses not be allowed to identify him as the shooter, but otherwise contemplated them being able to be called.
That was his request?
That was his alternative request, yes, Your Honor.
I didn't read the counsel as objecting to this particular remedy. Can you comment on that?
Yes, Your Honor. So this was not, the posture of the case at that point was on a motion to dismiss the charges and this alternative relief. They were not yet at trial, and so he has raised this issue on appeal. It wasn't this, it's a different situation, I guess I'm saying, than being at trial and trying to preserve the objection on the record at trial, Your Honor. To go to the remedy, we are asking that this court reverse and remand with direction to the district court that it consider in the first instant what a proper writ would be for Mr. Lee. And in Trombetta, the due process clause was interpreted that defendants be afforded an opportunity to present a complete defense. And Mr. Lee was not afforded this opportunity, first because of this officer's destruction of evidence, and then again with the trial court's remedy.
We're here on a habeas petition.
Yes.
And so, as we've stated, and that you undoubtedly know, it's a very difficult burden to meet. And Trombetta and Youngblood, in my reading, doesn't mandate a particular type of remedy for the violation. It seems to provide the trial court with discretion, given all that the trial court has to consider with regard to what the appropriate remedy might be. Why doesn't that really undermine your client's petition in this case?
Thank you, Your Honor. In Panetti v. Quarterman, the Supreme Court has explained that just because a principle is general does not mean that it cannot be applied unreasonably. And here, in Trombetta and Youngblood, the general principle is that a state's intentional destruction of evidence in bad faith is a violation of the Due Process Clause, and a remedy must be afforded. And our position here is that a remedy that was aimed at protecting the state from adverse jury inferences is not a remedy for Mr. Lee's and his due process rights and ability to present a complete defense. And in Panetti, the Supreme Court explained further that AEDPA does not prohibit a federal court from finding an application of a principle unreasonable, even when the facts are different than the case in which the principle was announced. And so, while Youngblood and Trombetta did not reach fashioning a remedy themselves because there was not constitutional violations in those cases, the Supreme Court still contemplated that a remedy be afforded to the defendant in those cases.
So is it your representation that there was no remedy?
If Mr. Lee had availed himself of the remedy, he would have been worse off, Your Honor. He did not try and call these three witnesses because there was a lot of risk and very little upside. It wasn't like Youngblood, which there was no bad faith on behalf of the state. It was just a negligent destruction of evidence. But the defendant there was still able to present evidence about the destruction and received a jury instruction saying that the truth of that destroyed evidence may be inferred against the state. And this is how circuits across the country have interpreted or have afforded remedies, even in cases of negligent destruction of evidence. So where there's not a Youngblood violation, but still trying to ensure that a defendant has a fair trial. And so if Mr. Lee had called these witnesses, he would face a lot of risk. He didn't know what the officers might say, what the witnesses might say. He didn't have a way to impeach them, and he wasn't receiving the benefit of any inferences. And so for him to avail himself of the remedy, there was a lot of risk and very little upside when you're talking about a murder trial.
Did he have access to these witnesses?
After the state, yes. The one witness was interviewed by a defense expert, but the other two were not. But he did later on, after the destruction of evidence was established, he did have access to them, Your Honor.
And do you know whether or not at that point he or his counsel, whether his counsel interviewed the witnesses to see what they might say at trial?
I don't know that, Your Honor. I'd like to turn back to the trial court's remedy here. And the transcript makes clear, and again, because Mr. Lee did not request suppression, the trial court, after denying his request for dismissal, imposed suppression on the state, but then in the very next sentence said, but if the defense is intending to talk about the destruction of evidence, then that might reopen the door. And when asked for further clarity, the trial court described it as a problem if the defense was intending to talk about the destruction of evidence, because, and I quote, the inference is going to be that we want the jury to believe they did something improper. And Your Honors, I would respectfully say that they did do something improper. They intentionally destroyed evidence, and they acted in bad faith.
And counsel, I'm sorry, can you point me to where in the record that particular line is?
Yes, Your Honor. That is in our additional appendix at page 35. And the trial court there on that same page goes on to explain that to solve that problem, that was why the remedy was going to be what it was.
And do you know what the transcript page number is by any chance? It's okay if you don't, I can
I
look
do
it
have
up.
it right here, Your Honor. 1 second. That would have been transcript page 35 and at the district court docket 2616.
Thank you.
26.
26-16, yes, Your Honor, and page 23.
Where Attorney White's is asked the question.
Yes. Or right before that, the court says, yes, that entire page has the explanation, Your Honor.
And that goes to your argument here regarding the remedy. But the very fact there was a lot of risk to calling the witnesses, right? That to me goes to why there was a remedy, because the witnesses could have identified your client. And there's a lot of discretion in the scope of the remedy. Are you arguing that there's just no remedy at all?
If he availed himself of the remedy, Your Honor, yes, we'd argue that there was no remedy. The remedy the trial court was fashioning was directed at protecting the state from adverse jury inferences. And again, this also took off from the table his ability to talk about the destruction of evidence, which, looking at other cases from other circuits and in Youngblood itself, that was the ability to present a complete defense. He obviously no longer had this ability to present any evidence about these witnesses because what they said in December of 2013, because it was destroyed. But then he also no longer had the ability to fully present evidence about the destruction, as is relatively standard in not just criminal cases around the country, but also in civil cases, as spoliation instruction, adverse inference instruction is standard if you find that the other party destroyed evidence so that you could not have it to your benefit. And so, yes, we would be saying that the remedy was designed to protect the officers from adverse jury inferences, and so that is not a remedy for Mr. Lee. That was a remedy aimed at protecting the state.
Was there an adverse inference request made?
There was not, Your Honor. If there are no further questions, I will reserve the rest of my time for rebuttal.
Thank you.
Thank you.
We'll now hear from Mr. Kellis.
May it please the court. John Kellis on behalf of the Billy Warden Molanzek. Your Honors, this court should affirm the district court's judgment in order denying habeas corpus relief. The district court correctly concluded that the Wisconsin Court of Appeals did not decide contrary to or reasonably apply established federal law. The district court was correct, and I'm here to ask that this court conclude the same. Certainly here we have Mr. Lee's Youngblood Trombetta claim. To the extent that, and this wasn't really, I guess, addressed during my Hurt on the Other Side's argument, we recognize that there is I guess the Wisconsin Court of Appeals interpretation of Trombetta and Youngblood, and this argument that this is contrary to Youngblood and Trombetta based on the terms that the court uses and the test that it employs. And as we pointed out, I think Nichols recognizes, this court's decision in Nichols recognizes that that's not I guess, contrary to, but even to the extent that this court maybe has a different interpretation of Youngblood and Trombetta, even that would at most establish a circuit's interpretation of it that differs from the state courts, and even that wouldn't necessarily make this contrary to Supreme Court authority here.
Can we back up
Sure.
and understand exactly where you're going? We have a lot of deference we need to apply here. The ADIPA standard is not favorable to your opponent here. Isn't it shocking that state officials destroyed evidence saying we don't want the defendant to be able to get it in discovery?
You can trust that if there's one thing I'm here for today, it is not to commend law enforcement and the state actors that were involved in destroying this evidence.
And given how it occurred, are we going to see a lot of these? Is this something that's going on left, right, and center in Wisconsin courts?
I certainly don't think it is. As a former prosecutor, I certainly never saw it myself. I get that this is alarming. I understand why this gives this court pause. And I'm not here to defend the officers or the state actors that were involved in this. That's not my intention at all. Ultimately, though, this court is not tasked with deciding whether the officers did wrong here, whether there were better ways, and I know my partner on the other side has kind of laid out some of the other avenues that could have been taken by the state to protect these witnesses and make sure that, short of destroying evidence. But again, that's not what this court is tasked with doing, nor was that what the district court was tasked with doing. Ultimately, the question is whether that Wisconsin Court of Appeals decision that considered his arguments was contrary to an unreasonable application of the U.S. Supreme Court's authority, and it wasn't. Ultimately, this question about whether there was a contrary, whether the decision was contrary to, I want to focus on what the Wisconsin Court of Appeals did here, because as acknowledged in the reply brief, I mean, the Court of Appeals got to the same conclusion. It ultimately is operating under the position of there was a due process violation here based on the evidence destruction. So the supposedly differing tests that were used to arrive to get to that conclusion, the starting point was that the court recognized there was a problem. Really, the question was whether the remedy was appropriate here, whether that was an erroneous exercise of discretion. And looking at Youngblood and Trombetta, it's clear there's very little guidance presented or provided that guides courts as to how it is that you're supposed to craft that particular remedy. Now, I know that there's always going to be claims that dismissal is the only appropriate remedy. That's the only thing that can serve or can serve as an appropriate remedy. But it's not, and I think this case is an example of why that doesn't need to be done. I mean, the trial court here determined that there was a due process violation and ultimately decided that it wasn't going to dismiss the case, but it was going to preclude the state from calling these witnesses, but it allowed Mr. Lee to do so if he so chose. And
but without an adverse inference instruction.
Without even a request for an absent, or without such one. Certainly that could have been presented, and maybe we don't know how that would have been handled by the circuit court. There's this notion that the circuit court was so steadfast on protecting the state, and I disagree. I mean, ultimately the court allowed him to call these witnesses, and he had an opportunity, if he wished, to interview those witnesses. At least one of the witnesses was interviewed by a defense investigator as well. And as far as this, catch-22 that's alleged here, it really wasn't one. I mean, he could have called these witnesses. If they were to implicate him or claim that he was the shooter, they had additional, the subsequent interviews that were performed, they could have been impeached with that, in which they then also didn't implicate or name Mr. Lee as the shooter in that situation. The officers could have also been called. And then I guess even for the destruction of evidence in and of itself, I mean, if, you know, this evidence could have been presented without even mentioning the evidence destruction. If the defense wanted to get there to try to paint this as the state's trying to frame this man, they did these interviews and they destroyed it. I mean, I guess that then could be the justification for why the state would be able to explain why it was that this evidence was destroyed. But really, Mr. Lee kind of wanted to have his cake and eat it too. He wanted to prevent, you know, he wants the jury, I guess, in a way, to hear about the evidence destruction, but also not allow the state an opportunity to explain why that was done. But in the end, when you read the Wisconsin Court of Appeals decision, you see that there's a very thorough analysis about why it was that this particular remedy was not an erroneous exercise of discretion. And it lays out all the various considerations that it had here. And ultimately, given the fact that the Supreme Court has provided very little guidance, I guess, as to what the appropriate remedy in this situation should be, I think that when you look at how thorough the Wisconsin Court of Appeals reviewed this, the, I guess, lack of really firm details on when the remedy should be appropriate, I don't see how the district court could, or for this court could, for that matter, conclude that that was an erroneous or unreasonable application of Trombetta or Youngblood. As far as Mr. Lee's Brady, or claim under Brady, again, the determination was not unreasonable. The Wisconsin Court of Appeals concluded that even though this evidence was suppressed, that he failed to establish that the evidence was favorable to him or material to a determination of his guilt, and the court aptly supported that conclusion. The fact is that it explained that this evidence, it wasn't as though there were allegations that these individuals named a different person, provided a description that was inconsistent with Mr. Lee, and also this I guess the red herring, if you will, this assertion that these witnesses must have said something that implicated Paul, otherwise police would not have went and arrested him. And again, I call it a red herring because it's clear from this record why it is they pursue Paul. Paul is in an altercation with the victim immediately before the shooting. He's captured on video fleeing from the club immediately after holding what appears to be a gun. This wasn't rocket science about why these officers went after this individual and went to interview him and suspected that he was the gunman. This speculative assertion that it must have been something that these individuals said that led them to that is unfounded. And quite frankly, we have a detective's testimony, sworn testimony during the actual trial that explained when we met with Paul, I told him, I lied to him. I told him that there were all these individuals that were pointing the finger at him. He was adamant that it wasn't him. And the officer, the detective, acknowledges at that time that no one had implicated him at that point. So that goes to confirm and reaffirm that this wasn't this wasn't a situation in which individuals named a different person, and that's the reason why they went and pursued Paul instead of Mr. Lee in this situation.
Was Mr. Lee allowed to raise the point about Paul Lee's arrest during the trial?
I know his theory. I mean, his trial theory was one of a third-party perpetrator. He pointed the finger at Paul as being the individual who was the shooter, and that it wasn't actually him. I believe that I'm sorry, I don't know if they specifically asked the question about whether Paul had been arrested, but that was the trial defense, was that it was actually Paul and not him that was the shooter. And I think as far as the Brady determination of this not being exculpatory or impeaching, I've explained that, but I think the biggest thing here is the materiality analysis here, and the reasonable probability that the proceeding would have been different had evidence been disclosed. Again, evidence wasn't exculpatory, but I mean, I think looking at that evidence of guilt, I mean, we have 7 or 8 individuals who hear this confession or who hear him make statements. He could not help himself but tell, it seems like anyone who would listen, that he was the shooter. So even, I mean, I guess even if this evidence, you know, would have been gathered, I guess, under this Brady analysis, I mean, we have all of these individuals who hear him confessing to this shooting, and this isn't officers interviewing him trying to put words in his mouth or anything like that. We just have many individuals who have come forward and without any clear incentive or motive to lie about this had all pointed the finger and said, yes, he was the one who came or who acknowledged that he was the shooter. We also know that he was there. So given the strength of the evidence case, particularly based on, again, his presence there, the many individuals who actually heard him confess to the crime as well, there isn't a reasonable probability of a different result in the proceeding had that evidence been disclosed. So in the end, I guess what I want to stress is that we're not here to defend what the police did. And I acknowledge that this could have been handled differently and should have been handled differently. But again, I reiterate that the question before this court is not whether police should have done something differently or even whether Mr. Lee's due process rights were violated by the destruction of that evidence, but whether this was an unreasonable application of Supreme Court authority. And the Court of Appeals, Wisconsin Court of Appeals decision was very thorough. It laid out the standards. It explained why it believed that the remedy chosen was not an erroneous exercise of discretion. And absent Supreme Court authority suggesting that was improper or that case dismissal was the only appropriate remedy in this situation, under this standard, under federal habeas corpus review, the district court was correct to deny his petition, and I'm asking this court to affirm. With that, I will, unless the court has any additional questions, I'll yield my final minute.
Thank you, Mr. Kellis.
Thank you.
Ms. Walsh, rebuttal.
Thank you, Judge Lee. I'd first like to acknowledge that the district court, in denying Mr. Lee's young blood claim, focused on elements of Brady, saying that these interviews could not have been favorable or material. That is not an element of young blood. Young blood focuses on whether the exculpatory value of the evidence was apparent to the officers before the destruction. And here, that is what the trial court found. The trial court found that the officers knew the nature of the evidence before it was destroyed, and actually went at length to say, if this evidence was not potentially exculpatory, why would they have acted in all the different ways that they did regarding this evidence?
I guess just so that we can streamline this for us, if we find that there was a young blood violation here, fast forward, the remedy that was provided by the court, what Supreme Court case did that go against?
We would say Youngblood and Trombetta itself, Your Honor.
So, and what would Youngblood or Trombetta have required?
So that's back to what I was discussing about the general principle of these cases is that he be provided a real remedy. And the district court here did not get to that issue of a remedy because it found that the evidence was not material or favorable, and so no Youngblood violation. But we believe that a proper remedy here, we would ask that you reverse and remand and allow the district court to decide for the first time what would be a proper writ in this instant, because it has not yet had the opportunity to reach that issue. Going back to the trial court's remedy, I would like to elaborate on how the destruction of this evidence led that the remedy would be put Mr. Lee in a vulnerable position. Again, this is not a case where we're talking about some notes were destroyed, but the report that those notes were transferred into has survived, or a transcript of these recordings survived, but the recordings themselves were gone. The officers destroyed everything, or I would first say, did not follow procedure and did not have these records transcribed, uploaded into the evidence folder. They were kept on the officers' personal accounts, but then also obviously destroyed the one copy of what these witnesses said and the maps that they drew of where the shooter was moving. And so juxtaposing this evidence of what it could have said to what we had at trial, there was no eyewitness that said that they saw Mr. Lee with either a gun that night or that they saw him shoot him. So this was 3 eyewitnesses, and the officers had testified that after the evening that they spoke to these 3 witnesses, they went and arrested Paul because they had reason to suspect that Paul was the shooter. And that is consistent with what we know of Paul having been directly in an altercation with the victim moments before the shooting. The victim was shot at a very close range to the head, at most a few inches away. And my counsel here on the other side had mentioned that the 7 confessional witnesses had no reason to lie. I would point the court that 2 of those witnesses were next to Paul Lee during this altercation and were on video fleeing the scene in the seconds after the shooting, and one changed his clothes and discarded them in a nearby dumpster, which are not necessarily actions that of a completely innocent bystander. They were right there, and they never testified that they saw Chong do it, only about this later confessional, and they were close friends of Paul's as well. Before I close, I would like just to say that Mr. Lee was not trying to have his cake and eat it too. He did not have the benefit of this evidence that was destroyed forever. He also did not get the benefit of talking about this destruction of evidence. If he availed himself of the trial court's remedy and brought up these issues, he was not getting the benefit of the jury inferring that this evidence would have been beneficial for him. Instead, he was going to be stuck with an unknown of what the officers were going to say, an unknown of what potentially these 3 witnesses were going to say about what they had seen. And these other cases where defendants their Youngblood cases are remedied with an instruction, there the state is not getting the opportunity to justify its actions. The point is, if this evidence is destroyed forever and the defendant does not get to use it, a remedy has to give them something. And so a remedy that does not give him the benefit of it, but instead posed many risks, of which he had no way to impeach the officers or the witnesses. He had no way to know what they would say or prepare. That is not a remedy at all. And that is why, Your Honors, we are asking that you reverse and remand to the district court so that it may consider for the first time what a proper writ would be for Mr. Lee.
Thank you very much. Thank you very much, counsel. Particular thanks, Ms. Walsh, to you and your colleagues, Ms. Darnell and Mr. Morrell, for taking this by recruitment and representing your client ably.
Yes.
Thank you very much. We'll take the case under advisement. At this point, the court will take a 5-minute recess. We will now proceed to a third case this morning. That's Murdoch versus City of Chicago. Mr. Flaxman?
Please, the court. Unless the court has specific areas in which they'd like to direct me to immediately, I'd like to address 4 areas in my presentation. The first is the Alcorn decision. The second is the special order of the police department. The third is the administrative order of the chief judge of the circuit court. And the fourth is the misapplication, we contend, of Rule 12C in this case. In Alcorn, the court was confronted with a novel claim. The plaintiff contended that the plaintiff's decedent had committed suicide because of a municipal policy that prevented him from posting bond at the police station. This court in jail suicide cases has always looked for and insisted upon some showing of fault, that somebody did something wrong, but they knew the person who killed himself or herself was at risk. None of that was here, and the claim underlying Alcorn was a fanciful claim. It wasn't going anywhere, even if he had been held for 65 hours before being allowed to post bond. It had nothing to do with his death. The court, though, in its decision said where the law is that you have, as long as you receive a bond hearing within 48 hours, even when you were arrested on a warrant and there's been a judicial determination of probable cause, that's proper because the Fourth Amendment allows the government 48 hours to hold a bond hearing. In Mitchell versus Doherty, this court, in a very thoughtful, comprehensive opinion, rejected that argument. It said no, that the 48-hour rule, as we've held repeatedly before, is just for a judicial determination of probable cause when there's been an arrest without a warrant. It has nothing to do with when there's an arrest with a warrant, nothing to do with bond. It's just when there's an arrest without a judicial determination of probable cause. The Alcorn decision was not circulated to the court. It was not the subject of a hearing in banc, and it should be viewed as non-binding dicta that does not control this case.
When I'm looking at Alcorn, it says, given Riverside, the answer is obvious. Federal law does not prohibit presenting the arrestee to a local judge, provided that this is accomplished in a reasonable time not to exceed 48 hours. And so, is there a suggestion that Alcorn stands for the proposition that the bond hearing has to also happen within 48 hours?
That's what they said. And Riverside says that the 48-hour rule doesn't apply when a person is arrested pursuant to a warrant issued by a magistrate and a showing of probable cause. That's just page 143 of Riverside. So I don't know what the court was thinking, but they were...
Where do they tie it to the bond hearing?
The issue in Alcorn was what the court viewed as the second bond hearing mandated by the chief judge of the Circuit Court of Cook County when people were arrested on a warrant issued outside of Cook County.
But in the opinion itself, is there a representation that the bond hearing has to happen within 48 hours?
Yeah, I think that's absolutely clear. That the city reads Alcorn in their brief at 28 that a person arrested on a warrant that specifies a bond amount does not have a constitutional right to pay that bond to police immediately following their arrest. The Fourth Amendment permits a state to require that the arrestee must appear in court before posting bond. And I think at page 1064 of the Alcorn opinion, the court states that Riverside County allows the police to hold a person arrested on a warrant for a bond hearing, even when bond has been set in the warrant, as long as the hearing occurs within 48 hours of arrest. The city of Riverside had nothing to do with arrests when there's a warrant, and the court
And
got
you
it
said you were
wrong.
on 1064 of that opinion, where that language is?
That's what my notes show it was. I don't have it. I could probably find it, but I think it's there.
Here we have the plaintiffs, they were arrested based on warrants, right?
That's right.
For which some judicial officer has already determined that there's probable cause.
That's right.
And so, looking at Mitchell, the Mitchell court concludes that, in short, we hold that the Fourth Amendment does not require even a bail hearing within 48 hours after arrest, right?
Well, I guess it's express holding that there is no requirement. That if that was our holding, it would say the Bail Reform Act was unconstitutional, and it would be contrary to common law, and that's what the loose language in Alcorn says, and the court should not follow it.
So here, were all the plaintiffs provided a bail hearing or bond hearing within 48 hours?
Well, no, there is no bond hearing. What we pointed out from Mr. Neal's testimony is that when you're arrested on a warrant and you're brought before a judge other than the one who issued the warrant, that judge is going to say, I don't know anything about this case. I don't know about you. This other judge said it should be $500 to get out. That's what same bond to stand. There is no second bond hearing. The other thing, which is getting into the third point, the administrative order, if we read that carefully, the way plaintiff would ask that the court read it, it doesn't mandate a second bond hearing. The last paragraph.
I guess where I'm struggling is if you're asking us to find that there was a Fourth Amendment violation.
Oh no, I'm asking you to find that the district judge was wrong in dismissing and granting a motion for judgment as a matter of law. I'm not, and the law is settled that when there's been a determination of probable cause and you're arrested on a warrant, you have a liberty interest in posting that bail and getting out of jail. That's what I think this court held in Doyle versus Alcea in this footnote, and I think 6 or 7 other circuits expressly hold that on different theories, but they all agree that once bail has been set, you're entitled to post it, and holding you for no reason is a constitutional violation.
Under what amendment?
There is no reason in this case. That's the whole thing. The special order that is that underlies this
I'm trying to
case.
drill down on what is the constitutional violation.
It's a Fourth Amendment violation. You have
and
a
what
liberty
is the
interest.
Fourth Amendment violation that you are articulating for the court?
That it's an unreasonable seizure to hold someone when they are in custody following a judicial determination of probable cause where bond has been set and they're ready, willing, and able to post bond.
How quickly must they be allowed to post bond? So in other words, what if there is no administrative way, or they can't, the processing and all of that stuff? What would you say about, is there a time limit in which they must be allowed to post their bond?
No, there is no time limit, but
Is it a reasonableness? I mean, does the Constitution impose any time limit?
I think, but we have to apply this to the City of Chicago Police Department and the way they apply their policy. The City of Chicago, after you're arrested on a warrant, checks to make sure that you're the person sought in the warrant and that there are no other warrants seeking that you be held. Once that's done, there's a sergeant who's authorized to accept bond. And when somebody has the bond, they should be allowed to pay it.
But even if we find that they violated the policy, the state policy.
Well, they didn't violate the state policy.
I want to look back to the previous question that Judge Lee posed is at what point along the spectrum, the time spectrum, does continuing to hold them become unreasonable?
This isn't about time. This is about in specific application of this policy.
Under the Fourth Amendment, the question is, allow me to finish.
I'm sorry.
It's fine. Under the Fourth Amendment, the question becomes, unreasonableness. And so I'm asking for you to articulate what makes it unreasonable.
It's unreasonable, and I'm sorry if I cut you off. I
It's
didn't
fine.
mean to do it. It's unreasonable to hold somebody overnight at the police station and transport them in a squad roll, handcuffed, to see a judge in the afternoon who's going to say, same bond to stand. So the bright line test for determining who's been aggrieved by this policy is when you're held overnight, brought to a judge, and you're able to post bond. And
So
that's
immediately,
immediately, you know.
when those other things have happened, able to pay, bond has been set, you must be immediately released.
And those are all, as we pointed out, and I think we filed the class motion, those are easily ascertainable facts. We have records of who's transported and when they're there. And we have records of when they're allowed to post bond.
So what
when
if,
they get out.
I guess I'm just trying to figure out what the rule would be. Let's say you're arrested in the morning at 7 a.m., right? And you are not allowed to post bond until 5 p.m. that day. Would that be an unreasonable application?
That would not happen in Chicago. If you brought in at 7, you're held until the next day.
I know,
you're brought to jail.
just go with me here, Mr. Flaxman. So I'm just trying to figure out, one of our tasks is to figure out and articulate a rule that would govern. And what you're saying, what you're providing us is kind of what the rule shouldn't be, right? You're saying that the rule can't be that they have to wait overnight. And so I'm just trying to ferret out what you think the rule should be.
Well, what the rule should be is unreasonableness, which would be a case-by-case determination. In our proposed class, unreasonableness is measured by being held overnight and being brought to see the judge the next morning.
You only get to the constitutional violation through Monell, and there I'm seeing some issues, because to me, if there is a policy, the policy is driven by the court orders. You either read them the way Judges Durkin and Feinerman did, and CPD's bound, or you don't read them that way, and then there's no express policy. So how are you getting to liability for CPD?
Well, the policy, the express policy, was adopted by the CPD in 2012, and nobody knows why or has been able to tell us why they adopted the policy. The general administrative order that Judge Feinerman said they're relying on was adopted in 2015. The city didn't amend its special order until 2012, and they maintained the special distinctions in their order, different than what the chief judge's order was, by saying, we'll let you post bond on a Chicago warrant, and we won't let you do that on weekends and holidays. Everybody else has to go see a judge who's going to let you post bond. The other thing is the question that is apparent from that special order, or the administrative order of the judge. Does he really say you're not allowed to post bond until you have a second bond hearing, as the Alcorn court described it? Or is he saying, if you're able to post bond, you can? The special order, which we set out in the brief in numbered sentences, the last 2 sentences are 1 paragraph. The first sentence relates to duties of the sheriff. The second sentence uses consistent passive voice, doesn't identify anyone, and seems to say that if you have bond, you can post bond and get out. I'm running out of time, sorry. I lost my train of thought, all right. What Judge Feinerman said was, well, it doesn't matter what the city's intent was in adopting the rule, which is different than the one that was subsequently articulated by the chief judge. It's an objective standard. It's sort of like qualified immunity. Could the municipality have concluded after 2015 that it should continue its rule because it was maybe consistent? But we don't have qualified immunity for municipalities. We have an objective standard. If we put this to a jury, the defense of, well, we were compelled by that circuit court order to adopt this policy. The jury would think, I hope, well, why did you adopt the policy in 2012? Why did you adopt a different policy? Why didn't you conform your policy to the court's policy in 2015? Why don't you do it in 2019 when you changed the policy, or when you reenacted the policy? Those are questions. A jury would say that wasn't compelled. That's just something some very creative lawyer made up to try to win a lawsuit.
Thank you, Mr. Flaxman.
Thank you.
Oh, I'm sorry.
I did have a follow-up question, because we didn't touch on this, is the equal protection claim, and I didn't know if you had presented already why the policy itself was irrational.
Well, there's no distinction between somebody arrested in Bolingbrook or somebody arrested in Chicago, or somebody arrested in a suburb of Chicago outside of Cook County. What the city argued is that, well, the clear system doesn't work outside of Chicago. And then which is facts that should not be considered under Rule 12C motion. We showed, however, that the clear system has nothing to do with warrants, that it's the lead system, which is universal throughout the state. And the city said, well, it doesn't matter because there's no Fourth Amendment violation under Alcorn. Thank you.
Thank you. Mr. Merrill, is it?
Yes, Merrill. Thank you. And may it please the court. Plaintiffs were each arrested on warrants, and they were required to appear in local bond court before they could be released. 2 general orders of the Circuit Court of Cook County required Chicago police to take that action, and the requirement to appear in court before posting bond was upheld by this court just 2 years ago in Alcorn v. City of Chicago as not a violation of the Fourth Amendment. Other than their equal protection claim, which is based on a counterfactual reading of the police department's special order, plaintiff's case is nothing more than a request to revisit and overturn Alcorn. The district court's grant of judgment on the pleading should be affirmed. Starting with the merits of their 2 claims, the Fourth Amendment claim is the exact claim raised in Alcorn, which this court rejected 2 years ago. Just like here, the plaintiff in Alcorn challenged the policy of not allowing certain warrant arrestees to post bond, and this court held that that requirement does not violate the Fourth Amendment because, consistent with Riverside County v. McLaughlin, quote, federal law does not prohibit presenting the arrestee to a local judge, provided that is accomplished in a reasonable time not to exceed 48 hours. Alcorn, in this case, involved the same purported policy and the same Fourth Amendment claim, and Alcorn is entirely and unequivocally dispositive. Plaintiffs argued in their briefing, although not here today, that the holding of Alcorn decision was dicta. We believe that is nonsense. It was the central holding of the Fourth Amendment claim, which was squarely presented to the court. This court is presented with alternative grounds all the time to affirm judgment, and this court's choice to choose just one of those bases in its opinion in Alcorn, the Fourth Amendment merits, not causation, does not transform that holding into dicta. Simply put, Alcorn should be the beginning and the end of their Fourth Amendment claim.
Do you agree with counsel that there is contradiction in Mitchell-Daugherty versus Alcorn, looking at those 2 cases?
No, I don't believe so. In Mitchell, they were dealing with, the person was still attending court. They were going for a probable cause hearing. They were just saying the separate determination of bond could take place at a later time. So what Riverside County is looking at is when you arrest someone, there are steps that police officers have to take incident to that arrest. And so the 48-hour presumption is simply a recognition of those many steps that police officers have to take and say, well, if it's within 48 hours, we're going to presume, of course it could be overcome, that it was a reasonable amount of time. Here, they were arrested, and incident to that arrest, the presumption should apply because that is how much, before they were taken to court. Now, there's even opinions of this court in Chordick and in Portis where there's fine-only offenses, and the court said that the rationale underpinning McLaughlin still applies because this police officer still has to take essentially the same steps instant to arrest before they could be released on a fine-only offense. And so while here there was a court appearance that by law, state law, they had to attend, even if there wasn't, this court has indicated that a kind of a similar considerations come into play underpinning the rationale in McLaughlin. Now, as for their equal protection claim, they allege that the city's express written special order Individuals arrested on weekdays on warrants in Chicago are permitted to post bond, while persons arrested on warrants from outside of Chicago or on weekends are not. I would like to say that that allegation finds no support in the text of the special order. On the contrary, the written special order states that both categories of arrestees will be transported to court. Section 4B states that the station supervisor will ensure that all persons arrested on a Cook County Sheriff's warrant returnable to the 1st Municipal District, that's Chicago, are transported from the district arrest to the court of issuance. And just 2 lines below that, in Section 4B, it also states that all persons arrested on warrants outside of the 1st Municipal District or on warrants on weekdays and holidays will be transported to court. In other words, the plain text of the special order states that both categories of warrant arrestees will be transported to court. So therefore, appellant's equal protection claim, which exclusively pled municipal liability based on this express written order, is based on a completely made-up counterfactual reading of the city's written special order, which is utterly discredited by the text of the special order that they attached as an exhibit to their pleadings, which is why it was able to be decided on a judgment on the pleadings. Now, while
So your concern is there is no distinction between the 2 classes?
yes, in the written special order of CPD, there is no distinction between the parties giving rights to an equal protection claim. It's a fantasy based on what the special order actually says in its text.
What about in practice?
I mean, we're at the pleading stage. I don't have any discovery to know whether the practice is different, but at the end of the day, they did not base the factual cause of their Monell liability against the city isn't on some widespread practice or failure to train or whatever it be. It's based on the explicit special order, which doesn't say what they say it says. Now, while those 2 bases, the Alcorn rationale for the Fourth Amendment claim, the failure to plead any equal protection claim is enough to affirm, an alternative reason why both appellants' claim fail is that the city's special order is not the cause of their purported injury of having to attend court. Municipal liability requires the city's policy to be the moving force behind their alleged injury, and without such causation, their Monell claims must fail. So if we look at the text of the various orders involved in this case, the language of the city's special order essentially mirrors the language of the 2 general orders issued by the Circuit Court of Cook County. One of those court orders requires police to transfer to court those arrested on warrants on weekends and those on non-Chicago Cook County warrants. That's Order 2004-02. And the other court order requires all persons arrested in Cook County on out-of-county warrants to appear on court. That's Order 2015-06. In other words, even if the Chicago police had never adopted its special order, the Circuit Court's orders would have still required each of the appellants to appear in court. Because of this, the special order could not have been a necessary condition of appellant's purported injury, because again, if it didn't exist, the legal requirement would have remained the same. As this court has repeatedly expressed in Snyder v. King, in Bethesda Lutheran Homes, in Surplus Store, a city's decision to adhere to a mandatory directive from state law is not an exercise of any meaningful independent discretion, let alone final policy-making authority, and it is the state law, not the follow-through, which is the cause of the alleged harm. Here, the court's orders, not the city's follow-through in executing those court orders, was the moving force behind their purported injuries. And just to be clear, this is not an affirmative defense, at least not in the way that appellants portray it in their reply brief. Causation is an element of a Section 1983 claim that appellants bear the burden of proving. If appellants cannot identify a city policy that was the actual moving force behind their injuries, then their municipal liability claim can't proceed. If your honors have no further questions, we're prepared to rest from the briefing on the other points.
Thank you.
For these reasons, the judgment of the district court should be affirmed.
Mr. Flaxman, I'll give you another minute if you have something on rebuttal.
This is the first time I heard the argument from the city that the special order does not require, as the district judge said, that persons arrested on weekends and holidays on Chicago warrants have to go to bond court. I think the court can read the special order itself, but it's really surprising that we haven't heard that before, and the case has been litigated since 2020. That this comes up now the first time in oral argument. I think it's just exuberance on the part of my brother at the bar. The equal protection extends not just to suburbs of Chicago and Cook County, not just to weekends and holidays, but it also extends to suburbs of Chicago and Cook County. And we haven't heard any explanation for why the city adopted that policy in 2012. And probably if we have a trial, there will not be any. Thank you.
Thank you, Mr. Flaxman. Thank you, Ms. Farrell. We'll take the case under advisement. The next case is United States versus Anderegg, case number 251354. Mr. Goldman, whenever you're ready.
Good morning, Your Honors, and may it please the Court. Ross Goldman for the United States. In dismissing the possession count in this case, the District Court endorsed an unprecedented and erroneous extension of Stanley versus Georgia. The District Court's decision is inconsistent with what the Supreme Court has since said about Stanley. The Court's decision conflicts with Supreme Court direction regarding how to interpret Supreme Court precedent. The Court's decision is at odds with the courts of appeals that have talked about Stanley as applying to adult obscenity, and the Court's decision squarely conflicts with the three other courts that have considered this exact issue and held that Stanley is no bar to a Section 1466 Big A possession prosecution. And what's worse, the consequence of the District Court's decision will be to increase the real risk of real harm to real children in the form of sexual exploitation and abuse, harms that Congress specifically and permissibly targeted when it enacted Section 1466 Big A. As we outlined in our brief, there are two main distinctions between Stanley on the one hand and Section 1466 Big A on the other that combine to place this statute comfortably within the generally applicable categorical rule that obscene speech is unprotected. First, Stanley is about adult obscenity. Section 1466 Big A is only about and only reaches obscene depictions of children engaging in sexually explicit conduct as that term is defined in 18 U.S.C. 2256, paragraph 2. The second key distinction, Stanley is about, quote, mere private possession. That's the phrase Stanley used 10 times in its opinion. And the Supreme Court's post-Stanley case law makes clear that commerce-connected engagement with obscene materials falls outside the scope of Stanley. Paris Adult Theater said that there is no, that commerce in obscene material is unprotected by any constitutional doctrine of privacy. It is these two features together that make this case fall within, again, the general rule that obscene speech is unprotected and outside the narrow Stanley exception, which applies to non-commerce connected in-home possession of adult obscenity. With respect to Stanley being limited to adult materials, adult obscenity, a couple of key points. First, the material at issue in Stanley involved adults. Second, Georgia's primary justification in support of that statute was what Osborne later called the weak and paternalistic interest in protecting the adult possessor from the purported harms of possessing and viewing adult obscenity. And we know from Stanley, too, that it mattered that there was no risk of harm to kids. The court says at page 567 of the opinion that there was no danger. The Supreme Court found no danger in that case that that material would fall into the hands of children. And that's why.
But we also have Ashcroft versus free speech, and a lot of what you're getting at, Ashcroft squarely addressed.
Ashcroft, I'm sorry, Your Honor?
Squarely addressed some of these concerns.
So with respect to Ashcroft, I think it is meaningfully and totally distinguishable on the ground that at issue in Ashcroft, of course, was a statute that reached material that showed no actual child and that was not obscene. And so what the court was being asked to do in Ashcroft, and you see this the way they talk about the panel dissent, that they would have had to adopt the panel dissent of creating yet a third bucket of unprotected speech, that is depictions of children engaging in sexually explicit conduct where no actual child is shown and where the material is not obscene. And the court there said in the context, for example, of the child protection rationales, that those rationales were not enough to unprotect that otherwise protected categories of speech. But 1466BA is the solution to the Ashcroft problem because of the obscenity element. And so because of the obscenity element, this statute cannot reach any material, for example, let me just step back. In Ashcroft, one of the main concerns that you see throughout the opinion is this concern that it could reach art or movies, and the court cites Traffic in the movie American Beauty. There is no conceivable way that 1466BA could ever reach that material because of the obscenity element. And if a fact finder were to determine that that material carried serious literary or artistic value, it would fall outside Miller. We would lose on the statute. So that's why Free Speech Coalition is no problem here. And multiple courts of appeals, Arthur, Shales, Worley, have all held correctly that 1466BA solves the problem that Ashcroft identified. And the key difference here is that, again, going back to Stanley, Osborne makes clear that the right in Stanley needs to be measured by the weak and paternalistic interest that Georgia was advancing. That interest could not be less afoot here. This statute is not about protecting Mr. Anderegg from himself. As I said, this statute is about protecting real kids from real harm, the grooming, the normalization of the sexual exploitation and abuse of kids, the whetting the appetite, the prosecution problems that would persist that Justice Thomas and Justice O'Connor foreshadowed in their Free Speech Coalition
But don't we
concurring
think
opinion.
we're dancing a little bit farther away from the issue? This is an as-applied challenge. He's not attacking the entire statute. He's attacking the Stanley exception applies to count 4, which is possession of obscene material in the home. And so where are the guardrails, or I guess why is the position as applied to Anderegg? Is there any question where the material was possessed?
No, I mean, the facts I think are going to show that he possessed it in his home.
Okay.
So the reason why the as-applied challenge, the Stanley-based as-applied challenge fails as to Mr. Anderegg's in-home possession of these materials is because the right in Stanley does not apply to obscene materials depicting children engaging in sexually explicit conduct, and does not apply where that in-home possession satisfies one of the statutorily required connections with interstate commerce, a connection we will have to prove at trial. And so it is, again...
And so Stanley is limited to that of adults.
That's right, Your Honor. And
is it because you're leaning on Osborne for that interpretation?
Well, Osborne certainly helps that interpretation, but so does Williams, where the Supreme Court said, talks about Stanley as saying the government may not criminalize the mere possession of obscene material involving adults. And then a couple page later, Williams again says, this is 2008, that the statute there, quote, precisely tracks the material held constitutionally prescribable in Ferber and Miller, obscene material depicting, parentheses, actual or virtual children engaged in sexually explicit conduct.
Again, I think we're taking this language and extrapolating it away from the as-applied challenge. He's not attacking the other ways, the other counts. He's attacking here simply the possession count. And so the Williams case, and I think we've done this a lot below, is merge child pornography and obscene material. They're not the same. Two different statutes that guide both of those decisions. And in Williams, when we were looking at the material or the language from the Supreme Court in Williams, I think that the page that you referenced just now, when he says that there's the block quote, that this behavior, right, there's no violation under the First Amendment for obscene material, actual or virtual, of children. And so are you taking that language and suggesting that it was overturning the language in Stanley?
No, and to be clear, it's not that there's no violation, it's that there's no protection for obscene depictions of children engaging in sexually explicit conduct. I think that's on its face exactly what Williams is talking about. And so, and we're not trying, and I certainly don't mean to move away from the as-applied challenge at all in this case. The as-applied challenge is this. Stanley protects the in-home right to possess AI-generated images of children engaging in sexually explicit conduct, even where that possession satisfies one of the statutory connections with interstate commerce. And our response to that argument is that Stanley is not that broad. And there are background principles, I think, that further inform this. So the idea that Stanley is a narrow exception to the otherwise generally applicable non-protection of obscene speech is something the Supreme Court has said time and again.
Mr. Goldman,
Ferber, yes, Your Honor.
Getting to that point, in count 4 in the indictment, it specifically alleges that any visual depiction involved in the offense had been shipped and transported in interstate and foreign commerce. Right? So even on the possession count, that's one of the things you have to prove. And doesn't that bring the facts of this case then closer to 2,000 foot of super slip?
100%, Your Honor. Our commerce-based argument in this case is grounded largely in that line, and there's 6 or 7 of them, the post-Stanley 1970s cases, where defendants were repeatedly urging the Supreme Court to extend Stanley to various commerce-connected engagements with obscene materials.
Whereas Stanley, there were no allegations about how he got the materials. They were just focusing on the possession in and of itself.
Correct. That's exactly right, Your Honor. And every single time, and there were multiple, every single time the Supreme Court was asked to extend Stanley to commerce-connected in engagement with obscene materials, the Supreme Court said no. When the Supreme Court was asked to extend Stanley to material that shows actual children, the Supreme Court said no because of the harm imposed on real children. The harm imposed on real children here by this statute is what makes this case so much more like Osborne than like Stanley.
But don't you run?
Delving to that a bit, sometimes the government tries to or alleges interstate commerce more broadly by saying, for example, the depictions were created by a computer that was sold in interstate commerce, right? But here, and that would satisfy presumably the interstate commerce requirement for the statute itself. But here, the government's taking an even more, I guess, rigorous approach and saying, well, not only was the computers and the materials transported interstate commerce, but actually the depictions themselves were.
So the indictment charged 1466 Big A D4, which is the images, the obscene material traveled interstate commerce or were produced with materials that traveled. Charged both. Again, we have not gone to trial yet, obviously, but I expect our evidence will prove the produced using materials prong, the computer, and the stable diffusion software that was downloaded to generate these images. But that's the commerce-connected engagement with these materials. And the reason we know...
But isn't the key distinction between this and Stanley the fact that the visual depictions were also transported in interstate commerce? Right? That's what the indictment alleges. And any visual depiction involved in the offense had been shipped and transported.
Well, I think the indictment alleges both prongs of D4. The images were produced and were... the images traveled in interstate commerce and were produced using materials that were traveling in interstate commerce.
Right, but it's not an or, it's an and.
Right, but I think the indictments can charge in the conjunctive and be proven in the disjunctive. And so what I expect our trial evidence is going ultimately to prove will be the produced using materials.
Well, then that raises a question in my mind about how far, at least the indictment itself, putting aside the subject matter, whether the indictment itself takes it out of Stanley, because the cases after Stanley were dealing with the use of commerce or use of depictions in commerce, buying it, sending it, receiving it, et cetera, et cetera. And here you're saying the government can prove count 4 by relying upon the second prong, that is used by materials shipped in interstate commerce, without having to show that the depictions themselves traveled through interstate commerce, which seems to distinguish then count 4 from the cases that you were talking about.
So I think what those cases it is true that the actus reus in those cases was something other than possession. But the lesson that emerges from those cases is that Stanley, and again, you have to look at Stanley through everything the Supreme Court has said since about Stanley. And the lesson from those cases is that Stanley protects a place, the home, and that activities, the engagement with commerce that extend outside the home fall outside that narrow protection. And again, Paris Adult Theater says,
But
we have,
here, there wasn't just simple possession. There was
I'm
the
sorry?
shipping and the transporting.
I'm sorry, say
Here is the indictment says that it was beyond just the mere possession in the home. There was the shipping and the transporting of the visual depiction.
So that's the way it is charged. Right. Well, we have to charge one of the D1 through D4 predicates, or jurisdictional connections with interstate commerce. And what we charged is D4, which has the two parts to it: the materials moved in commerce, the obscene material moved in commerce, or was produced.
But you're saying that you can prove them either one. You don't have to prove both.
No, for sure. That's right. That's right. We don't have to prove both. And this produced using materials, this jurisdictional language is not unique to 1466 Big A. It is in 2251, 2252, 2252 Big
Going
A.
back to Judge Lee's question, though, is this what the argument that this is what pulls it away from Stanley?
This is part of why it gets pulled away from. So there are two reasons that this statute falls outside of Stanley, and they can exist independently, sufficient bases to remove it from Stanley, but certainly in combination. It is the adult-child distinction and the commerce-no commerce distinction that combined make this outside of Stanley and within the otherwise generally applicable rule that obscene speech is unprotected. And I do just want to say one last thing.
Go ahead. Oh, go ahead.
Taking it outside of Stanley, your rationales for taking it outside of Stanley, I understand that Ashcroft versus free speech is not obscenity. You have I get the legal argument there, but I don't just read the syllabus and the holding for Ashcroft, right? I look at the reasoning of the Supreme Court. That's part of the precedent we need to follow. How are your reasons for taking this outside of Stanley consistent with free speech when I read in free speech rejecting some of the very arguments you have in terms of the rationale for, well, it creates the potential for grooming. It essentially creates the market, creates more appetite. I agree that those are all concerns, but they seem to me to be concerns that the Supreme Court has told me I'm not to look at here.
So I think the doctrinal point is critical here. What the Supreme Court was rejecting in Ashcroft was this idea that the grooming, the normalization, those concerns are by themselves enough to unprotect otherwise protected speech. In other words, the starting point for that material, maybe this is a useful way of thinking about it, the starting point for the material at issue in Free Speech Coalition, as the Supreme Court was thinking of it, was protected. No actual child, so not Ferber and Osborne, not obscene, so not Miller, protected speech. And then there was the argument from the government was, here are all these child protection concerns that we think are sufficiently grave and compelling that you should now unprotect this otherwise category of protected speech. And the Supreme Court said no. But that's why 1466 Big A is the solution to this problem, because of the obscenity element. And because of the obscenity element, this statute is only going to reach speech that is constitutionally unprotected. And from that perspective, what the child protection concerns are doing is they're not being used in furtherance of unprotecting protected speech. They're being used in furtherance of driving home just how different the purpose of this statute is from what motivated the Supreme Court's decision in Stanley. And we know from Osborne how critical it was to the holding in Stanley that the justification that Georgia was advancing in defense of that statute was that weak and paternalistic in protecting the adult possessor, which is different in every way from what this statute's about. And may I make one last point here?
Yes, go ahead.
Okay. Thank you. The last point I want to make is just on the adult-child point. One of the lessons from Ferber, and Ferber says that when the government is regulating to protect children, and in particular to protect children from sexual exploitation and abuse, the government has greater leeway in undertaking those regulations, even where doing so may otherwise touch on constitutionally sensitive rights. And that language has been picked up by Knox in the Third Circuit, Vincent in the Eighth Circuit, and that is critical to why, again, the fact that this statute is so narrowly drawn at obscene images of children engaging in sexually explicit conduct that is designed to protect real kids from real harm is what takes this case outside of Stanley and places it comfortably within the general rule that obscene speech is unprotected.
Mr. Goldman, could I ask you about stable diffusion? We have this AI kind of overlay over this case. And I just wondered if I could ask you some technological questions. In free speech, Justice Kennedy mentioned morphed images and said, we're not dealing with morphed images in free speech. And that was before this whole AI thing kind of came about. And one can argue that, AI images are the ultimate morphed images, right? Is there any way to disaggregate an AI image? In other words, if the stable diffusion, obviously, like a lot of other AI large language models, takes all these images from the internet, like real images, and then kind of combines them. Is there any, and at least from the literature, it seems that sometimes the person that it creates is unrecognizable from any real person, and other times you can tell who that person is. And it's a direct correlation to images out there on the internet. Is there any way to figure out the source of an AI image that stable diffusion creates? To your knowledge? I mean, I know you're a lawyer, you're not an AI expert, but I'm just curious.
Well, let me try to answer your Honor's question this way. I think part of what's maybe tripping you up is a terminology point. So when we think about AI-generated imagery, I think it's useful to think about it in terms of two separate buckets. One is like a deepfake image or a morphed image, which take a picture of a real person, use AI to manipulate it to create some now fake image, but of an identifiable person, but the image is not real. And then you have, for lack of a better word, a pure AI-generated image that shows no identifiable or actual minor. That pure AI-generated imagery, we know from the sort of investigative facts in this case, that's what this case is about. This is the defendant using stable diffusion, entering prompts, I'm making a point here, I'm just paraphrasing, but create a picture of this child doing this in this scene, and then stable diffusion generates a responsive image to that. That child, and I think the image in this case totally bear this out, is photorealistic, but we know in many ways indistinguishable from an actual child being abused. But we know from the discovery that it is not an actual identifiable child.
Mm-hmm.
Okay.
Is that at all responsive?
Yes.
To your, okay.
Yes, thank you.
Okay, thank you.
I'm going to maybe not pronounce this right, but it's Mr. Bugney?
Yep, perfect.
Okay, great.
May it please the court, I'm Joe Bugney here on behalf of Mr. Andreg. I'd like to begin by answering your question. When it comes to the jurisdictional part of this, the government's theory has always been that it was produced in the home. That was in count one, but also that the computer itself, which had been shipped, it was an old, not MacBook, but a old computer, that what had been used on it. So it wasn't that these were transported across state lines. This has always been within the isolation of his home. And I'd like to touch upon your question, Judge Pryor. What we're really dealing with right now, and where I think, Judge Kolar, your pushback is that when it comes to Ashcroft, you're looking at the overriding of a right? These are First Amendment protected, right? If you begin with the premise that Stanley is a First Amendment case or a substantive due process case, it doesn't matter, that it protects a right, then what they're doing is they're trying to take away a right. And they're saying these countervailing interests allow us to take it outside of that right that stood for 60 years. Now, how can you do that? Well, you can't, right? That's up for the Supreme Court. If the Supreme Court wants to say, look, we're going to reweigh this, and we think that Osborne somehow controls, well, that's for them to say. But no court has ever said that.
So is it your contention that Stanley is not limited to obscene material involving adults?
Oh, absolutely not. I think obscene material, so it is not limited. One, that's never in the argument, right? And if you were to take the state's argument or the government's argument, well, it's only actually protects pornographic films. What about pornographic pictures? Why does the level of abstraction go only to adults?
Because the Supreme Court said in U.S. versus Williams that it's limited to adults.
I don't think it said it's limited to adults, right?
Involving adults.
No, but that's the example it's giving.
That's what it says.
No, but it's not that it's limited. Sorry, I don't mean to cut you off, John. No, I don't think that it's limited in United States v. Williams, that becomes part of the holding, that we are now saying that Stanley is only for adults, but instead that Stanley stands as a geographic limitation. And that's what it is. Within the privacy of the home, you could have it, whether it be a dirty magazine, whether it would be a racy novel, whether there would be anything else that could be considered obscene, whether it would be crush videos. All of those things would find shelter within Stanley. And they'd say, you can't receive it, you can't transport it, but within the privacy of your home, you may view it, you may possess it. That's what Stanley provides, and that's what that language it has. It keeps on going on. It says, look, the privacy of a man's own thoughts, they're not going to be, infringed upon by the state. Those are lofty promises, and they're promises that haven't been eroded. They haven't been taken, and they're saying, like, look, they haven't been extended. That's very clear. But it wasn't that Osborne said, look, this is only going for adults, right? They're saying Osborne takes us out of Stanley because it's for actual children. And we're going to adopt it because it's not the content of the images, but the way they were produced. That's what Osborne is getting at. So the geographic limitation of Stanley prevails. I think once you get that point right, and it's not limited to only adults, and it definitely extends to animals and extends to anything else that anybody else would have, then it becomes, how do you override it? Go ahead, Your Honor. I thought you were going to ask a question.
Nope.
Nope.
My eyebrows just do that sometimes.
All right, well, I was hoping it was foreshadowing a great one, or at least an agreement. And I think that's really the core aspect here, is that the state wants us to read into the Supreme Court case something that they hadn't read in. They want us to undermine a holding that maybe isn't popular or maybe they don't like, and that's fine. But it's not for this court. It's not for this court to make that call. This is an as-applied challenge, and as an as-applied challenge, it really is. We got to look at the facts. We peeked into the discovery and we said, look, this is how you're going to prove your case. You're going to prove your case based upon this, and it is the use of the computer within the privacy of your own home. And if that's going to be your theory of the case, then I'm able to say Stanley protects that. And Stanley protects that absolutely. And with that absolute...
So is there no contention that these images were shipped or transported?
Correct. Yeah. The other images were transported in counts 2 and 3. They were distributed. So that takes that aspect of it. Mm-hmm. But it's not that these images that he's charged with possessing, that they were otherwise produced outside of his home. It's that they're produced here on his computer within his own home. And you can look at that like the Justice Black dissent or concurrence, I can't remember which, in 37 pictures. It's like, look, you're going to relegate Stanley to this. That, like, you got to write the racy novel up in the attic. You got to print it in your basement and read it in your living room. Well, that's what he did. If that's what he did, then that's what that protection provides. And if that's what that protection provides, then this court can be comfortable with it. It can be very comfortable with it, because all of the other problems that the state may identify, they're also taken care of in counts 2 and 3. Whetting the appetite, distributing them, doing all those things that we say, like, hey, we want to be able to combat that. All of that can be taken care of in counts 2 and 3.
But what do we do in count 4, where it says that these images were shipped, transported?
Well, that's the way they pled it, right? Mm-hmm. But they're going to prove it, just like they allege in the conjunctive, they prove in this, or we all know that, right? And so it's going to be heroin, cocaine, crack, and marijuana, and then suddenly at trial it's only about marijuana or whatever it might be. Here we know how they're going to prove it. And so that's the allegation that we alleged. That's what we proffered in our motion to dismiss. And that's what the district court held. I think going back to your earlier cases, I think you'd have to say, is that clear error? No, the district court knew what the facts were. We had 90 pages of briefing. We had 6 motions. We've had 15 bail hearings. That's an exaggeration. We've had many bail hearings. The court's very familiar with the facts of this case.
Would you concede that if the AI-generated data isn't produced on that computer but goes off to some website, some AWS or whatever, that is housing something that, and then the image comes back to the computer, then it's transported? I mean, you're making it sound like this is really just, produced on the computer sitting in someone's house.
Yeah.
But I'm not sure. I'm not trying to get into technological. I'm certainly no technological expert, but are you conceding the government could prove the charge that way and not run afoul of Free Speech Coalition, Stanley? I mean, and not kind of remove that protection you're saying, if they're showing, well, wait a second, it somehow got to the computer, and the computer itself didn't do everything necessary to produce that image.
I think you would then be going into the receipt category. So if it was charged as a receipt category, that's what you would have, and that's what we usually have with, the download of the child pornography or whatever else that we often have. But I wouldn't give that away. No, I'd say actually, like, I don't know how that image is created. I know it's created on that, least alleged that it's created on that computer at that time. Now, whether or not how it would all work within the Stable Diffusion, it goes to AWS. We never had that, so I don't want to give that away, let alone if it's multiple computers. Judge Lee, you were going to ask a question? No.
No, just reading. Thank you.
No. I do think that coming back to one kind of pivotal point here is, what does Stanley actually say, right? And that's where I thought about maybe doing a dramatic reading for my first 90 seconds, but I thought your question was really what I wanted to address about the D1, because I would hate to lose it on, or D4. I'd hate to lose a case on this misidea of like, hey, what is really going to be at issue here in an as-applied challenge? Stanley is asserting the right to read or observe what he pleases, the right to satisfy his own intellectual and emotional needs in the privacy of his own home. He is asserting the right to be free from the state inquiry into the contents of his library. Whatever may be the justifications for other statutes regulating obscenity, we do not think they reach into the privacy of his own home. If the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own home what books he may read or what films he may watch. Those words are not given an asterisk. Those words are not dialed back. They present a right that's absolute, and a right that is only absolute within a person's own home. And that's where this is. All of this took place within his own home.
So that's why you're not attacking count one, the production.
I did attack that. I thought that in the judge's order, he says, look, the logic of Stanley should be such, right? And if you look at that Judge Black quote, but he said he split the baby and said, like, I think Stanley protects it. You can't read Stanley any other way than I'm reading it, right? It says it protects it, but I'm not willing to go so far as to production. Right? And so he just said, I'm not going to give you count one, and I can't take an interlocutory appeal in the denial of motion to dismiss. So that issue is not before this court. It's limited to count 4. And count 4, I get it. I would be asking for an expansion of Stanley in some way. I'd be like, hey, you got to actually keep this geographic and think about it when it comes to production. I'm not asking for an expansion. I'm just asking for an application. I'm asking for a very simple application of a very simple principle that's been around for over 60 years, or about 60 years, and that everyone has accepted.
So you don't think you're asking for an expansion of Stanley into CSAM materials?
No, I'm just saying into obscenity. So if you mean CSAM, do you mean CSAM as in child pornography?
Right.
No, I think Osborne is very clear. When it comes to actual child pornography, as you said in the beginning, we have to use those terms precisely.
Well, you want to extend it to virtual child pornography, right?
Well, virtual obscene material.
Yeah, that's it. I just wanted to, actually, I'm going to dial back from both of you. I just actually wanted to apply to obscene materials. Like virtual or not, whatever it is, it's protected within the home, within Stanley. So I don't need the caveats, and we don't need to have these sort of gradients. Just like if I were standing up here and it was a Crush video, right? I wouldn't be like, I need you to extend Stanley to Crush videos. Under 18 USC 48, those actually have to be obscene for it to be criminalized. I'd say within Stanley provides that. It's the same privacy of a person's home. Obscenity does not reach within that. So it's not an extension at all. It's just a simple application within those 4 walls. That's all I'm asking for. So it's not the different contents any more than it would be. I believe that the allegation was that Stanley, it was a male-female, sexual act, right? If it was 2 men, that wouldn't be an expansion of Stanley. Any more than 2 women, it wouldn't be an expansion of Stanley. It would just be Stanley. Stanley applies for obscenity. And if you make that rule and you make that decision, which I think is very firmly rooted in Supreme Court precedent, then this is a very easy case to decide. And it just comes down to that simple principle. With that, I don't know if the court has any other questions. I mean, this is a very important case to my client, and I want to make sure that there are none unsaid.
Thank you very much.
Thank you, Your Honors.
Mr. Coleman, I'll give you a minute.
Actually, sorry, can I have one?
Of course.
Sorry.
Yep.
There is one small thing, and it was actually in the state's brief that they pointed it out. And I would just like to I know you have very smart law clerks that didn't miss this, though I did, is that United States v. Toma, 726 F. 2nd, 1191, is actually, so it's found actually in the state's brief, page 30, note 15. And here, this court, back in 1984, said, it is clear the defendant has a constitutionally protected right to possess obscene materials in his home. This is actually dealing with child pornography before child pornography, so CSAM. This is from this court.
I'm sorry, page 30?
Page 30, note 15 of the government's brief.
Okay,
Yep.
I'm with you.
Right. We also agree if the government had violated this right in the course of investigating defendant, then it would be truly outrageous standard would not be applicable. Right? We do not agree, however, that the CF campaign impermissibly induced defendant to leaving the Stanley zone of protection and selling his material. This court, 40 years ago, was willing to admit that there is a Stanley zone of protection, and that was dealing with 2251, prosecution, and dealing with entrapment. So it's not as though this is, I'm asking for anything that's, never been decided before, never been, thought of before. This is something that's been consistently decided. And it's one that, there isn't a lot of case law on it because I think most people, they don't charge it as possession any more than the Ostrander case, right? Courts are quick to recognize Stanley is very clear on what it protects. You can't leave the house, but within the house, you have that. So I just point the court to those two. Thank you very much, Your Honors.
Thank you. Mr. Coleman, I'll give you a minute.
Thank you, Your Honor. With respect to Toma predated Osborne, which held that obviously the possession of child pornography in the home was constitutionally unprotected. Toma also predated this court's decision in Anderson, which also predated Osborne, but said that it was unclear whether the in-home possession of child pornography was constitutionally protected. A couple of brief points in response. Mr. Bugney read from Stanley about the First Amendment, the right to receive information ideas in the home, and he said that that has never been dialed back. But Osborne makes clear that that language does not reach as far as Mr. Bugney makes it sound. That language does not reach the possession of child pornography showing actual children because the interest, the harms that material imposes on children is such to bring it outside of Stanley. That's the argument here. The harms that this material poses, the threat of harm that this material poses to real kids is what makes this case so much more like Osborne than Stanley. And Judge Kolar, in response to our dialogue before about Free Speech Coalition, the prosecution concerns that were in play in Free Speech Coalition are ever more pronounced today. And I would urge the court to look no further than the images in this very case, where these children who are being sexually abused are totally indistinguishable from actual real children who are being actually really sexually abused. And that indistinguishability, that technological advancement, aside from the doctrinal point that I made before, but that technological advancement puts that concern ever more starkly in relief in this case and puts the prosecution rationale front and center with respect to all of the other child protection interests that are deeply at stake in this prosecution, and which, again, Congress specifically impermissibly targeted when it enacted Section 1466, Big A. I see my time's expired. I'm happy to answer any other questions for the court. If not, we would urge the court to reverse.
Thank you.
Thank you, Your Honor.
Counsel, thank you for both arguments today. They were very insightful. All right, the next case is United States versus Coleman, case 232760. Mr. Luthen, it's always a pleasure to see you. Whenever you're ready.
Thank you, and may it please the court. Elliot Louthan on behalf of Mr. Clifton Coleman. This case requires us to change gears and shift from the pretrial phase to the sentencing phase. There are two issues on appeal. One, a Brady claim related to the leadership enhancement, and secondly, the stash house enhancement. Starting with the Brady claim, to level set, there are three elements: favorable, suppressed, and material. Only the latter two are contested here. So to begin with suppression, the government's argument is a wolf in sheep's clothing. The government would have this court shift Brady obligations onto defense counsel. And thankfully, this court doesn't need to look any further than the Supreme Court's decision in Kyle's, which says that where the government, that Brady reaches situations where the government failed to volunteer exculpatory evidence, never requested, or requested only in a general way. And that clear statement of Brady doctrine rejects the government's contention that where defense counsel is well aware of evidence but declines to request or review it, the government has not suppressed evidence. I don't think the court needs to examine that in any further depth than that. And the closer question really is the materiality element, as it often is in Brady cases. And here, what's unusual or atypical is the equivocation that Judge Rowland expressed. We see inoculating statements all the time, even more so than this court sees, because oftentimes we have to advise clients that they need to dismiss their appeal, refile an Anders brief, right, because of inoculating statements. That's how common they are. This sort of equivocation is uncommon. It's not the norm. And it's why this court should send the case back just for a limited evidentiary hearing to determine whether these interview recordings would have made a difference. And in the briefing, I use a statistical spectrum because I really think it helps illustrate how these interview recordings could make a difference, right? We know from evidence that a preponderance burden is 50% plus 1. Based on what Judge Rowland said, that I'm torn. I think this is a very, very close call. I think this is a very, very close case. The government's saying it has overwhelming evidence, but I don't find that. Maybe she's at 51 or 52%, right? And I'm not here submitting that these interview recordings would move the needle from 90% down to 49. But if they're just a few percentage points, right? If they contain information about other alternative supplier sources, that very well could be the difference between this leadership enhancement applying and it not. And for Mr. Coleman,
your request for an evidentiary hearing, would we need that if we have the summaries?
No. And the answer why is that they're not, the recordings themselves are no substitute for the summaries are no substitute for the recordings. In the same vein, if the government had access to body cam footage, we wouldn't accept a law enforcement authored summary of what happened in lieu of that body cam footage. There's key context, the questions that were asked, the demeanor, things that a lawyer could glean, or even the defendant himself in reviewing that might pick up on and say, wait a second, you should look into that more. And based on our adversarial system, that is the province of defense counsel. So that's why we think that the summaries are not a substitute and not merely cumulative.
Did the government counsel kind of inoculate itself against that argument by accepting the defense position as to what the video could have shown, as to direct quotes, context, all that stuff?
The government below accepted it to a degree, right? But a proffer is no substitute for the recordings themselves, right? If you were representing Mr. Coleman below, right, the government didn't say, oh, here's exactly what was said or the questions that were asked, nor did they get into the alternative supplier sourcing, which I think really is what would move the needle more than anything else, from my vantage point as the appellate lawyer without full access to the record.
But aren't you, so regarding this alternate supplier, I think Jackson, right?
Yes.
Is his name. But the court understood and knew that at times that Mr. Watson and other people were sourcing their drugs from an alternate supplier. And so are you just speculating that there's going to be additional information on the videos that would kind of bolster that proposition? I mean, I'm trying to figure out what material information might be on the tapes that you don't have in the summaries that the court didn't know about?
Well, one, the court only knew about Jackson at this high surface level, right? We don't know the extent to which how much the street operation was purchasing from him. There was a proffer that Jackson is this middleman. What does that entail? Were there other folks besides Jackson, other suppliers besides Jackson? And that, given the amount of weight that we have at issue here, that is not a far-fetched speculation to imagine that street operation might have gone to other suppliers as well. I mean, from a law enforcement interview standpoint, those are textbook questions they're going to be asking, and the co-conspirators' answers, an unequivocal no, we didn't go to anyone else, or silence, or hesitancy. I mean, those are subtle nuances that very much could come into play. And so, no, I don't think Judge Rowland had the full picture. Most importantly, Coleman's trial lawyer was not armed or equipped with the full picture as to what occurred in those, or what was said in those interview recordings. To dovetail with that, I think it's also important to take a step back that here the government on appeal has not contested favorability. They're telling this court, you assume that it's favorable. And they leave it at that level of generality from my vantage point, because they don't want to go into any more of those details, right? And so there's something here to be explored. And so that's why recognizing that this claim wasn't raised below, the requested relief is a middle ground, right? We're not asking this court to overrule the enhancement. Judge Rowland was close to this case. I mean, her ruling was thorough. She did a great job. But given the equivocation she expressed, I think it would be the most prudent course of action for her to consider these interview recordings below, and then we can all be confident that the leadership enhancement should apply or should not apply.
Didn't the government, I thought I read somewhere, offer to provide the information to the judge? And the judge said, I'm not worried about.
My reading of the transcript is that at the hearing, at the sentencing hearing, the government offered to provide the summaries.
I see.
And not the recordings.
You're into your rebuttal time. Would you like to reserve it?
Yes.
Thank you. Mr. Peabody?
Good afternoon, Your Honor. May it please the Court, Tom Peabody for the United States. There was no plain error in the disclosure of the underlying videos of the co-defendant interviews for both suppression and materiality reasons. I want to start with suppression. And let me start by saying what the government's position isn't in this case. It is not that these were best practices, and it is not that the government's initial position below regarding the discoverability of the reports was correct. It is, however, that as this case comes to this court, with the reports having been produced 2 months before the sentencing, with the facts of the videos being written writ large across the record, referenced by the defense himself, and yet somehow never requested, even though the government offered to give the court the statements, and Judge Lee, you asked about that issue. It's in the appendix at page 60. What the prosecutor said below was it was an offer to give the quote-unquote statements. It's not clear whether it was a reference simply to the 302s or the videos themselves. Given that the discussion had been up to that point, the 302s themselves, I understand the defense's position on that, but the quote was a reference to give the court the statements. The government is not putting the Brady burden on the defendant. The defense is absolutely right about the general rule. The government has an affirmative obligation to disclose Brady material. That rule has a caveat, like a lot of general rules, and it's one that this court and many others have recognized. The government does not suppress evidence when reasonable diligence or here a desire with a reasonable diligence or here a desire to access the materials, there is no suppression. This court recognized it in Thomas. The Eighth Circuit recognized it.
Was there an offer made to the district judge to view the videos?
Judge, I think functionally there was.
What does that mean?
So sometimes what happens is prosecutors give over an index and say you can review anything you want to see here. That was not the case here. I believe that was for profound safety concerns about co-defendants who had chosen to speak. But as I was discussing with Judge Lee at page 60 of the appendix, the prosecutor says, if the court thinks they'd be helpful, I can give you the statements. And at that point, I appreciate that the statements themselves are not in the record, but in bold print in those statements is there is a recording that comes with this. The problem is the defense didn't want to see the recording. It asked only for the statements. And I would direct the court's attention to page 5.
So directing you back to my question, were the videos offered to the judge?
Not explicitly. The statements were more generally. But we are on plain air review, and I would direct the court's attention to page 5 of the reply brief, in which the defendant, in trying to grapple with this court's and other courts' reasonable diligence law, suggests that the court should reconcile and clarify that reasonable diligence means only access to already public information. If this court needs to reconcile and clarify law, there was no plain error. There was no obvious error, full stop. And I want to say a word about Kyle's, because I think the defense's reliance on it is well misplaced. Kyle's is a materiality case. It is not a case about suppression. The quote on page 433 of that opinion that the defense relies so heavily on is referring to Augers. Augers was explaining 3 situations in which the Supreme Court had recognized Brady claims. When a prosecutor knows about perjury, when there's a specific request made, or third, when there is no request or a general request made. If you refer back to Augers, pull the thread here a little bit, that description, the paragraph starts as follows. In many cases, exculpatory information in the possession of the prosecutor may be unknown to defense counsel. This is not a novel theory that the government is putting forward about Brady. It is a strenuous obligation sometimes, it is a sacrosanct one, but it is not oblivious to the realities of litigation. And when, as here, the defense is well aware of evidence and literally has summaries of what that evidence shows, courts, recognizing this court certainly on plain error, should recognize again that it is not suppressed. Let me turn to materiality unless there are additional questions on suppression. The defendant made full use of the summaries at trial with no objection from the government, and nevertheless, the district court decided that they didn't merit putting on the scale. The defense uses certain analogies in its brief about tilting a scale or statistical analysis. I think those are misplaced because the district judge, after hearing from defense counsel, spent 4 or 5 transcript pages on these 302s, and after the defense had an opportunity to brief the 302s in his sentencing memo, didn't talk about it in deciding whether or not the leadership enhancement applied.
Mr. Pippa, could I direct you to the stash house?
Sure.
Enhancement? As I understand it, Mr. Coleman was the landlord, right? He owned the apartment. Mr. Watson was renting the apartment. And Mr. Watson, as far as I could tell from the record, was paying Mr. Coleman, the rent he was paying was market rate, right? Because he was paying the same rent as the neighbor upstairs, who has no part in the conspiracy. Is there any evidence that Mr. Coleman had full access to the apartment? In other words, that he had keys or he can go whenever he wanted? I know that he went there 4 times to drop off drugs and to collect money, but I'm wondering whether there's any evidence with regard to what degree Mr. Coleman controlled access to the apartment.
No, Judge, I don't believe there's record evidence that he had keys or that, like in, I think, the Kraft case, he could let himself in and out whenever he would like.
Is there any evidence that Mr. Coleman was the one that directed Mr. Watson to rent the apartment?
No, Judge, I don't believe there is.
And the reason why I'm concerned about that is the district court seems to rely heavily on this notion of a possessory interest, right? But a landlord doesn't really have a possessory interest, or to the extent a landlord does, only has a limited one, because the lease transfers the possessory interest to the tenant. And so I'm wondering, I mean, technically there's a possessory interest, but it's kind of, only in certain limited instances. And I was wondering what other evidence there is of Mr. Coleman's possessory interest other than his interest, as a landlord in and of itself.
Judge, as to that one factor, possessory interest, I don't think there is other evidence. I view it as pretty darn compelling. I mean, having rented in the city, I think my former landlords would be surprised if there were a court ruling that they didn't have a possessory interest. They'd not be able to access it freely, but they still own the thing. And here, Mr. Coleman owned the stash house.
But the question is really kind of control, right? I mean, it's not possessory interest. Possessory interest is supposed to be indicative of control. And so part of control is access. And so I'm wondering if you could tell me what the record says about Mr. Coleman's access to the apartment.
So we know, for one, and the defense conceded this below, that unlike in Kraft and Montgomery, this is an out-and-out stash house. Mr. Watson does not live there. There was some allegation that maybe he had a girlfriend over there, but this is just a straight-up stash house. For the receipt coming from Mr. Coleman, the manufacturer with the Rouseys and Watson, and ultimately the distribution of drugs. In addition, I think, I'd be remiss not to point out, Judge Lee, that Mr. Coleman was the leader of this organization. He owned the apartment. He rented it to a co-conspirator, and he knew, as he conceded below, exactly what that apartment was being used for, a stash house.
But I think we've said that knowledge alone isn't enough, right? That there has to be some control. And so are you leaning upon the fact that he was determined to have a leadership role in the general organization to establish control over the stash house?
No, Judge. It's not simply that he was a leader. He used it for that purpose. I think the district court pointed out that there were at least 4 drop-offs of the supply for the group. He knew that his co-conspirators would then be manufacturing the drugs there for further distribution. He came there to pick up the cash. I mean, yes, he is the leader. He's also a core member of the conspiracy, as he depicted below, the supplier. And he's using an apartment he literally owns and has rented to a co-conspirator for the receipt, production, and sale of narcotics.
I mean, I understand all that. It just strikes me as strange that the rent is at market rates and that there isn't any evidence that Mr. Coleman was forcing Mr. Watson to use it. I mean, one would presume that if Mr. Coleman was really using it, that he would either not charge rent or the rent would be different from what he would charge the market.
I appreciate the point, Judge. I think that he may have gotten one over on his inferior in the DTO is not, I don't find it deeply probative given sort of the facts as I've described them. I see my time is up. Unless there are any further questions, I would ask that the government affirm the court sentence.
Thank you, Mr. Peabody. Mr. Loudon, you have about 2 minutes for rebuttal.
Thank you, Judge Lee. I'm going to try to make a point on each of the issues. On the Brady issue and this notion of the reasonable diligence doctrinal idea, I would direct the court's attention to the first footnote in the reply brief, which gets and examines how that language came to be. And it predates Kyle's, and it cannot be reconciled with Kyle's. Moreover, since then, this court has been clear. Really, this panel doesn't need to look any further than Bicknell, which also concerns sentencing in terms of how affirmative the obligation is. Turning to the stash house issue, the government still has not addressed why they could not have prosecuted Mr. Coleman under 21 USC 856, which is the stash house criminal offense. And to the point of the text in the guideline, there is a difference, a textual difference between maintaining and managing. The guideline could be written in a similar vein to the federal statute where it applies when the defendant maintains or manages a premises, etc. But it just uses the word, the verb maintain. And later on in the guidelines, in 2D 1.8, the Sentencing Commission distinguishes between maintaining and managing, and which implies that each of those verbs have independent meaning. And this court draws on those background principles in interpreting the text of the guideline. Finally, Judge Lee, to your questions about rent and the government's response that, well, surely it's a stash house. This very much rings in a similar vein to the arguments that were made in Montgomery, in Kraft, which is, yeah, this is close enough, but they had the obligation of building the record, and they didn't do so. And ultimately, the district court made two findings, neither of which was sufficient on the maintained element and the primary purpose element. If the court has no further questions, we'd ask for a reversal on the stash house enhancement and a remand for the evidentiary hearing.
Thank you.
Thank you.
Thank you, counsel. Our final case for today is United States v. Harbin, case number 251015. Ms. Ramis? You may proceed.
May it please the court, counsel. My name is Colleen Rame, and I'm with the Federal Defender's Office here on behalf of defendant appellant Eric Harbin. The district court in this case committed procedural error at sentencing when it relied on retributive considerations in imposing a sentence on the revocation of Mr. Harbin's supervised release. It was clear in the approximately 3 pages of the transcript where the sentence was announced and imposed that the court characterized supervised release as a grace extended to Mr. Harbin, explicitly called it an alternative to a prison sentence. That implied, and that is simply inaccurate, as we've demonstrated in the briefing and as explained in United States or in Esteris. So that is inaccurate both under the law and under the facts of this case. Mr. Harbin, it's clear in this case that Mr. Harbin originally was sentenced to almost a statutory maximum sentence on the underlying offense. He got 117 months out of a maximum possible of 120. He also got the statutory maximum sentence of supervised release imposed. There was no grace afforded to him, and to characterize it as a grace misconstrues the purposes of supervised release. The court also explicitly commented on the seriousness of his underlying offense and said, well, while you were punished for that, this is something that we have to consider, and this frames our whole conversation on revocation. So while pre-Esteris, and no fault of the district court, pre-Esteris, this court had said the court could consider the retributive factors in 3553A2A, as long as it also considered other factors. Esteris made it clear that that is not acceptable. So in reading the transcript, I believed it was clear. I know the government disagrees, but it is clear that that was at least some of the consideration of the district
Is the underlying offense.
It's the underlying offense, and and to the extent to which, I understand that Esteris said we are only deciding whether you can consider the seriousness and retribution for the underlying offense, which I would argue characterizing it as a grace absolutely does. It also really focused on the seriousness of the conduct, and the seriousness of the conduct implies retribution for the violation conduct as well.
Ms. Ramey, one of the things that the district court can consider is nature and circumstances of the offense.
Sure.
Still, right?
Yes.
And I know there's some overlap, but it seems like perhaps the nature and circumstance of offense deals with kind of what the offense conduct was for. You talk about the use of grace. On page 134 of the transcript, the district court says, the reality is that you did breach the court's trust and the grace that was afforded to you by way of supervision, particularly given the nature of your violations back to your original offense. Someone is continuing to possess cocaine, a Snoopy drug. Well, that's just a slide at that point, Mr. Harbin. One could read that to mean that when the district court talked about grace, it meant that in the context of the trust that the court placed upon Mr. Harbin, that he would abide by his conditions supervised release and that he would rehabilitate. That the court was giving him a break because it trusted that he would turn the corner, and that here we are later on and he hasn't turned the corner, he just slid back. Why isn't that a permissive kind of rationale for the court to use? Because we've talked about how, in revocations, one of the considerations, or one of the permissible considerations, is that the defendant breached the trust of the court.
Sure.
And here, the court demonstrated that trust by giving him a break at sentencing, or at least as articulated by the sentencing court. So why can't the court consider the sentence in that context?
Your Honor, part of the benefit of going last today was that I had a long time to sit here and think about my case. And one of the things that I was thinking about, and because I certainly appreciate the nuance here, this is a difficult thing that the Supreme Court has asked district courts to do, and I appreciate that. But so the best analogy that I could come up with was, I'm a parent of teenagers now, and I think the
condolences.
I thank you. I appreciate it. But it's sort of the difference between saying, I left for the evening and I left you home alone because I trust you, and you threw a party and I'm going to punish you because you breached my trust, versus you were grounded for a prior. You were grounded because you threw a party when you breached my trust, and then you begged me to say, can I go out with my friends this one night because this is really important, and I relented and I gave you grace from, I gave you some sort of reprieve from your prior punishment, and then you breached my trust again, right? And so then when I'm thinking about how I'm going to sentence that second breach of trust, I am imputing my frustration and anger and need to punish the first breach of trust. Does that make some sense?
Let me give you this hypo.
I don't know. Okay.
That
may be going far afield.
It's been a while since I've been a parent of teenagers, so I'll try my best. So let's say your teenager breaks curfew. And so you tell the teen, you know what, I should ground you for a week.
Sure.
But, I'm only going to ground you for 2 days.
Yeah.
Because I think you can do better.
Right.
And so I'm going to give you a break.
Yeah.
But the next time you do this, I'm going to come down hard on you.
Right.
Right? Why isn't that what's happening here? So in other words, the district court is saying, and why isn't that permissible? Because that's and the second time your teenager breaches your trust and misses curfew, then you say, well, I trusted you. I gave you that break because I trusted you. You breached my trust. You slid back. So now I'm going to punish you. I'm going to give you that week.
Right.
And why isn't that permissible?
Because Asteris says it's not. Because Asteris said you can't. Well, first of all, that's not what happened here. He got almost a statutory maximum sentence on both components. So to the extent to which the court, to the extent to which Asteris leaves room for that, I think that that is not applicable to this case. But more broadly, that's retributive for that first violation of trust. That is saying, I am compounding, I'm not focusing on simply the violation of trust that you have done here, and I understand that it feels like we should be able to do that. It feels like that is a normal human reaction.
I mean,
but when Congress pulled the
it seems forward-looking, right? It seems that's my scenario. Seems like you're not focusing on what happened before, but you're focusing on the most recent violation, that breach of trust. Isn't that what Asteris tells us to do? Is don't be back-looking, but look forward to that violation of supervised release. That's what you're really focusing on.
But in your hypothetical, and maybe I misunderstood, but I believe that the punishment was increased because of the prior leniency shown, and that's the problem. And that's the problem. That is backward looking.
But aren't we parsing the record here in a way that Asteris actually kind of predicted? And if I was reading it right, kind of said, well, that's what plain error review is for. You need to really make this specific objection. Now, your client decided not to have able representation below. How do we square whether this is plain error or the fact that your client was pro se? But it seems to me in a way we're doing what Asteris predicted and had a solution for.
Yes, Your Honor. The case law in this court is very clear, and the court has said over and over that when an issue arises in the pronouncement of sentence, in order to establish de novo review, we are not looking at, you do not have to object under Rule 51A. So while I understand that the Supreme Court invoked 52B and talked about plain error, this kind of error could arise earlier in a sentencing, and when a court is talking about the considerations and asking questions and things like that, in certain circumstances, there may be notice beforehand. There was not notice here, so he had no prior notice, and so the rules governing exception versus objection should apply equally to an Asteris error like they would to a Tapia error, to any other error that would arise in pronouncement of sentence. And I know I am over my time, but just briefly I'd like to say, even if we apply plain error, we still prevail, because there is an assumption that it is clear from the record that the court did consider these backward-looking retributive factors. There is an assumption that any consideration of that prejudices him, and the government hasn't even offered a reason that the court should exercise its discretion under the fourth prong of plain error.
Thank you.
Thank you,
counsel. Mr. Temkin.
May it please the court. Good afternoon, Your Honors. Eli Temkin for the United States. This court should affirm Mr. Harbin's revocation sentence under any standard of review. And if I may, I'll start by addressing the standard of review. My colleague correctly pointed out that the Supreme Court in Asteris has given district courts a difficult task. Asteris recognized that, but it addressed that point, the workability point, by saying that, sure, in that situation, the defendant has the obligation to point out the purported error to the district court. And that gives the district court the chance to clarify its thinking. On the spot, the defendant can know, was the district court relying on proper considerations in deciding my sentence, or was the district court going out of bounds? That cleared up the workability error, and it directs appellate courts on how to approach this also. When the defendant fails to raise it, and the appellate court otherwise would be tasked with going back and reconstructing what was going through the district court's mind. District courts at sentencing say a number of different things. They aren't just going through a checklist. They're addressing the defendant personally. They are addressing any victims or families that might be there. District courts are going to say a number of different things, and that's encouraged. It's always going to be possible to look back after the fact and to pull comments out in isolation. If the defendant thinks there is an error, the defendant can object, as Asteris set out. Beyond that, Asteris is the Supreme Court's considered view. The issue was front and center in Asteris, this workability question. The government raised the point in its brief. The defendant addressed the point in its reply brief, saying that plain error review is the answer, essentially. And at oral argument, it came up, Justice Sotomayor, to quote from page 50 of the transcript, she asked, "What is the workability problem? The district court says something wrong, you have to object." Justice Kavanaugh, later in the argument, essentially asking the government how it wanted to lose, given that it was going that direction. Justice Kavanaugh asked, if it's not objected to, it's not plain error. He was asking the government if it wanted the court to take that rule, which the court ultimately did, in the opinion. Other circuits to reach the standard of review question, since Asteris have been unanimous in applying the plain error review standard. As to the Stewart case from this court post-Asteris that addresses the standard of review point in a footnote, certainly Stewart points the opposite direction, but it doesn't settle the question for two reasons. First of all, Stewart, the parties did not address the point in Stewart. Stewart was briefed and argued before Asteris, and as the Stewart court noted, the parties agreed on this. The government conceded before Asteris that the de novo review applied under this court's pre-Asteris precedent. Asteris obviously changed that. The second issue as to Stewart is that Stewart just can't be reconciled with Asteris.
So if Stewart is in play, we are under 50. If we disagree, if Stewart is still in play, what would be the standard of review?
If this court's going to follow the Stewart footnote, then it would be de novo review.
Okay.
The Stewart footnote can't be reconciled with Asteris on this point. Asteris doesn't just say what happens when the defendant fails to object. Asteris says that the defendant needs to object, and that when the defendant fails to do so, review is under Rule 52B, only for plain error. It makes particular sense to follow the Supreme Court's directions here because this is a question about how to interpret and apply the federal rules of criminal procedure, which, of course, the Supreme Court promulgates. So the Supreme Court is saying how to apply its own rules. This is exactly the situation that the Supreme Court was talking about in Asteris, where, again, the defendant can get clarity on the spot, and appellate courts aren't going to need to go back and try to reconstruct what was in the district court's mind. I'll move now to the actual facts of this case, unless the court has additional questions. In this case, the district court sentenced Mr. Harbin for permissible reasons. It was not to punish him for his 2015 crime. And again, that's the right conclusion, whether reviewed for plain error or de novo. On appeal, the court is to consider the district court's sentencing remarks as a whole and not just isolated excerpts from those remarks. The district court here properly applied the breach of trust framework throughout its comments. Mr. Harbin violated the court's trust through his repeated supervised release violations, and the district court voiced its concern that Mr. Harbin was sliding back into his old pattern of using drugs and committing crimes. That triggered the district court's concerns for deterrence and protecting the public. To the extent the district court mentioned the underlying offense from 2015, it was towards those ends, which are permissible, of, again, deterring Mr. Harbin and protecting the public. These are forward-looking considerations, and they aren't problematic under Asteris. To the extent the district court mentioned the 2015 offense, it said it didn't need to walk through the details of that offense, and Mr. Harbin had already been sentenced for that. That's at page 121 of the hearing transcript, page 22 of the appendix. The district court wasn't sentencing him to punish him, wasn't imposing the revocation sentence to punish him for the 2015 offense. The idea of grace that the district court mentioned, Judge Lee, I believe you correctly identified that the district court was talking about supervised release as a grace, as a chance to get back on your feet, to reintegrate into society after a prison term. That's, again, consistent with this court's precedent addressing the breach of trust framework. And it's also consistent with the Supreme Court's characterization of supervised release as an alternative to a prison term and a chance for rehabilitation. The district court did mention seriousness a few times. Mostly that was getting to the violation conduct, and considering seriousness as the violation conduct is in bounds. Asteris explicitly says it's not issuing a decision on that point. To any extent the district court mentioned seriousness about the 2015 offense, it was saying that historically, but it wasn't relying on that in deciding the sentence. Again, the district court said it wasn't going to go into detail. It had already sentenced Mr. Harbin for that underlying offense. To any extent the 2015 facts factored in, that was to further the district court's forward-looking concerns for Mr. Harbin. All that said, there was no error here, let alone any plain error. Unless the court has any questions, the government asks the court to affirm the revocation sentence. Thank you.
Thank you, Mr. Tumpkin. Ms. Romay, I'll give you another minute.
Your Honors, the court led off essentially at the very beginning of its discussion of the sentence by explaining that it talked about the sentence that Mr. Harbin had originally received, and it did say, as Mr. Tumpkin said, I think it's, you've already been sentenced for that. But then it says, the court said, I think it's always important to recall anytime the court gets to a revocation that this is still very much rooted in the grace that you were afforded as part of that original offense. Immediately after calling his offense serious. And I understand that there are other considerations that the court had when pronouncing sentence, but I don't know what else to construe from this than that it was a consideration. That the retributive factors of 3553A2A were part of the mix of considerations that the court considered. And Asteris does not say that, if it's just a part of the mix, then it's not going to meet plain error. Asteris says, even under plain error, a court's order revoking supervised release and re-imprisonment will be affirmed unless it is clear or obvious the district court actually relied on 3553A2A because it did so either expressly or by unmistakable implication. This is express and or unmistakable implication that 3553A2A was part of the mix of things that the court considered, which we know under Asteris is wrong. I stand by my arguments on the standard of review, but I think under either standard of review, this should be remanded.
Thank you. Thank you, counsel.
Thank you, Your Honors.
The case will be taken under advisement. And with that, court will be in recess.